question resolved quickly. So I don't necessarily think it's going to be one of these cases where we're going to be waiting in the final days of June or early July for a decision, but I don't necessarily think we're going to be getting it sometime next week either.
All right, that's Amy Howe, co-founder and reporter at Scotus blog. You can find her work at scotusblog.com. Amy, thanks so much for the update.
Thanks for having me.
And joining us now to further discuss this case at the Supreme Court is a roundtable. We've got Chad Squateri in studio. He is a Catholic University of America School of Law professor. And joining us by virtually is Jonathan Adler, William & Mary University Law School professor. Gentlemen, welcome to both of you.
Thanks for having me on.
Good to be here.
Chad, I'll start with you. At issue here, as Amy just mentioned, is it's called the International Emergency Economic Powers Act, IEEPA. Talk about what the law says on that and how it can be used for tariffs, in your opinion.
Sure. So Amy's correct that the relevant legal language in that statute is language that empowers the president to regulate importation. And the statute gives the president various powers. At one end of the powers, the president can investigate certain importation. At the other end, the president can prohibit importation. So the president here has used the power in the middle, regulates importation. And the president claims that that statutory authority gives him the authority to impose tariffs. And I think the president is correct.
Why do you think he's correct on that?
Well, there is about 250 years of history that shows that the authority to regulate foreign commerce conducted via importation, that authority has always been understood to include the authority to impose tariffs. That is a well-known and traditional means of regulating commerce. So the ordinary meaning of the statutory phrase regulate importation includes the traditional and well-known power to impose tariffs. And if I could just pick with one little thing, Amy gave a great overview, but she says, and it's very common to say, that no president has ever used this authority to impose tariffs before. That's a little bit of a play with words because there was a statute before IEEPA that used the exact same statutory language, regulate ... importation, and that statute was used to impose tariffs.
By which president?
President Nixon.
Jonathan Adler, what do you think of that? Do you agree with what Chad Squateri just said?
Well, I think I have a different view of the history here. I mean, I think there are some very serious arguments in this case, and it's a very difficult case. But I think ultimately, especially when one looks at the founding period, one recognizes that the founders saw the power to impose excises and duties and tariffs as distinct from the power to regulate commerce. That in the founding period, the delegation of authority to issue tariffs was seen as something that was a very significant step and something that had to be very constrained. There's an amicus brief submitted on behalf of Connor Clark, another law professor, that points to this founding history, in fact, relying in part on the work of a former Trump administration official on this founding period and how carefully Congress constrained the power to exercise tariffs. And in the modern era, there's really an unbroken practice of never using emergency authority either under the IEEPA or its predecessors to remake trade law or to alter tariff schedules in a way that would be inconsistent with the broader body of trade law, because Congress has enacted a wide array of trade statutes that typically constrain the ability of the president to impose tariffs in particular. And to accept the president's argument in this case is to effectively say that the president can declare an emergency, not subject to judicial review, declare that there are extraordinary circumstances, not subject to judicial review, and then remake the entire international trading system without having to submit treaties to the Senate for ratification and without having to submit to any of the other constraints that exist anywhere else in trade law. And that's just an enormous assertion of power that does not have any sort of precedent. Drawing a line about why these tariffs are distinct from things that have been done in the past may be difficult, but I think it's fairly clear that the sort of power that's being asserted here does not have any precedent in this nation's history.
So what do you think of the, outside of that this is trade law, that tariffs are a tool of foreign policy and that the president should have wide-ranging power when it comes to foreign policy?
Well, I mean, look, that's certainly a very strong argument, and there's a lot of 20th century precedent that suggests that courts should be more flexible or more lenient in policing delegations of power in that context. Tariffs, though, are in part a special case because Congress has legislated so pervasively in the trade context, and that tariffs, unlike, for example, things like trade sanctions, are actually imposed not on foreign countries, but on American citizens. Tariffs, contrary to what the Solicitor General's brief suggests since the beginning, are paid by the importer. They are paid by American citizens, American companies. If these tariffs are struck down, the people seeking refunds will not be foreign nations, but will be people like the petitioners in this case who have had to pay the tariffs themselves. So while tariffs are often used as a tool of foreign policy, they really sit in this kind of special middle ground because the way they are imposed is by taxing individuals within the United States, not directly taxing foreign entities.
If you'd like to join our conversation, if you've got a question about the Supreme Court tariff case, you can give us a call. We've got Chad Squateri, law professor at Catholic University, and Jonathan Adler, law professor at William & Mary, with us. The lines are by party, so Democrats are on 202-748-8000, Republicans 202-748-8001, and Independents 202-748-8002. Chad Squateri, your response to the idea that this is a tax on American citizens and that is only for that is only within the realm the Constitution says for Congress to do.
Yeah, I think this is a fundamental misunderstanding of the tariff power. So people note that the tariff power can be used as a means of the taxation power, and that's correct, but the originalist and historical evidence is overwhelming that tariffs are unique. They can be both a tax or a means of regulating foreign commerce. And that's been recognized by James Madison, Chief Justice Marshall, Joseph Story, the revolutionary pamphleteers that said no taxation without representation. Those very pamphleteers said, by the way, commerce regulating tariffs are different than taxation. So here the president is using a regulatory tariff. So all of the arguments about taxation are rather besides the point. Here we're talking about the delegation of authority to regulate foreign commerce. The president is, of course, the leader of the United States on the world stage in the foreign context. And this is kind of at the height of presidential power.
So are you saying that even though it's effectively a tax on American importers, it is not considered a tax legally?
So, legally correct. And sometimes I think people are a little loose with these terms. You might say tax in an economic sense, and that it's imposing a fee on certain goods. But in a legal sense, it does not have to be a tax, and indeed these tariffs are not a tax in a legal sense.
Jonathan Adler, I want to ask you about a New York Times article about this. It says, will Trump's tariffs survive Supreme Court's major questions test? Can you explain what the major questions test is and how it is applicable in this case?
Sure. So in a line of cases going back to at least the 1990s, the Supreme Court has recognized that first, all power that the executive branch exercises, including the power to do something like impose tariffs, must come from a delegation from Congress. Congress must have enacted a statute that delegates that authority. And in this line of cases going back to the 1990s, the court has recognized that when what is at issue is a question of large economic and political significance, something very dramatic, the court should be reluctant to read that sort of power into the interstices of a statute. The line that's often used is that Congress is not going to hide an elephant into a mouse hole. So, for example, Congress held that the Food, Drug, and Cosmetic Act did not authorize the Food and Drug Administration to regulate cigarettes as drug delivery devices, even though you could read the text in a way that might allow that. And similarly, the court held that the Biden administration could not read existing statutes that granted the power to modify student loans as the power to forgive student loans altogether. And so the idea here is that the power to deal with economic emergencies that IEEPA authorizes, read against the background of trade law more broadly, should not be understood to grant this awesome power to remake all of the nation's trade relationships with every country on the planet, because Congress, if it had meant to give something that awesome, that broad, that extreme, would have said so. and that when it adopted the IEEPA against the background of how this sort of power had been used in the past, we should instead recognize that Congress was perhaps approving the sorts of actions that had been taken in the past, actions that had always been consistent with the broader framework of U.S. trade law, and not this power to essentially sweep that all away, even if one could look at the language and say, well, taxes can be used to regulate. This is the power to regulate foreign commerce or regulate importation. Therefore, anything goes. So the idea of the major questions doctrine is that would be such a major, large assertion of power that we should not lightly assume that the language can be interpreted in that way.
What do you think of that, Chad?
Well, I think Justice Kavanaugh had a really informative concurrence just last term where he explained that the major questions doctrine has never been applied by the Supreme Court in the foreign policy and national security context. And I think that's correct, and the logical underpinnings of the major questions doctrine make clear that the major questions doctrine should not apply in the foreign policy and national security context. This statute was explicitly granting the president emergency authority. So Congress is quite clearly knowing that they're giving the president very important and big authority. There's currently a debate on the Supreme Court as to what the major questions doctrine is. On one side, we have justices claiming that the major questions doctrine is what's called a substantive canon, promoting the value of something called non-delegation. And then the other side, we have justices claiming that the major questions doctrine is a linguistic canon that tries to look at how people ordinarily speak and use language. And no matter which side of the debate you fall on the major questions doctrine there, I think it's clear that it doesn't apply to the foreign policy context. And in the substantive context, it doesn't apply because if the major questions doctrine is supposed to enforce the non-delegation doctrine, well, the non-delegation doctrine itself applies very laxly, if at all, in the foreign policy context, so it wouldn't apply there. And if the major questions doctrine is a linguistic canon, well, there we look at, well, does Congress kind of intend to give a broad authority to the president in emergency context and foreign policy context? Of course Congress does. So no matter which side of the debate the justices might fall on as to what the major questions doctrine is, it just does not apply in a case like this.
I want to read you real quick, and then we'll take callers. This is from the amicus brief of the National Taxpayers Union Foundation. This is what they said, quote, "Trade deficits are not a sudden or unexpected development and are in fact a routine and ordinary event, the opposite of an emergency. The U.S. has run trade deficits continually for 49 years. Striking down the tariffs would not be catastrophic. Terminating the IEEPA tariffs would simply return us to the comparatively low level of tariffs that were in place at the start of the year." What's your response to that?
Yeah, well, I think the presidential declarations make clear that the trade deficits are a national security problem because they're hurting our domestic manufacturing base. So you only have to look at something like COVID-19, an emergency where domestic manufacturers very quickly transitioned from making things like bed sheets to making things like masks, or World War II, where our domestic manufacturers had to quickly transition from making things like cars to making things like planes and bombs. When our domestic manufacturing base is injured and not running along at a high level, it is a national security threat. Also, I think this gets to an important structural point. Who is to make this call? Is it going to be a group of like law professors filing an amicus brief, or the president of the United States who gets daily intelligence briefings? I think the court's going to side with the president.
All right, let's go to callers. We'll start with Ronald, North Carolina, Republican line. Good morning, Ronald.
Hey, good morning. I called. I was upset about what happened to New York City. The mayor and all voted in. The country's brain dead or something. People vote for him.
So Ronald, actually, we're talking about the Supreme Court now. Sorry, we've moved on. Do you have something on the tariffs?
Yes, the Muslims used to come in and use pilots to fly into the Twin Towers, and now we.
Okay, and here is Dan in Maine, independent line. Good morning, Dan.
Good morning. How are you? That's very funny. It seems to me that the problem is rather simple. Section 8 of the Constitution says the Congress shall have power to lay and collect taxes, duties, import imposts and excises to pay the debts and provide for the common defense and general welfare of the United States, but all duties. Imposts and excises shall be uniform throughout the United States. Now, there have been delegation by Congress to the presidency to issue some taxes, levies, tariffs. But if we would think about the Declaration of Independence says taxation without representation, and that's what's going on when the president, not the Congress represents the people. The president is the president. If he wants to be king, he should move to South America where he's buying up territory already, illegally.
Okay. Well, let's get a response, Dan.
Yeah, so he's correct that the taxation power vests taxation power in Congress. But there's another power, the Foreign Commerce Clause, which also can be used to impose tariffs. That clause is also vested in Congress, but Congress can more easily delegate it to the president. And again, to return to those revolutionary pamphleteers that the caller was talking about, the pamphleteers made clear that although there was no taxation without representation in Parliament, commerce regulating tariffs were distinct from taxation. So tariffs are a unique thing. They can be a tax or they can be used for regulatory purposes.
Well, right now, President Trump is giving remarks at the White House. He's hosting Republican senators at a breakfast. Let's listen in for a moment.
Many from prisons, many drug dealers. A lot of people came in from mental institutions. They want to give a lot of money to the people that came in illegally. We have to get them out. We can't. No country can sustain that. That's not like an attack on our country. In no country, these are not going to be productive people. These are going to be anti-productive people. And we can all have big hearts. I have a bigger heart than anybody, but we can't let that happen. It's time for Republicans to do what they have to do, and that's terminate the filibuster. It's the only way you can do it. And if you don't terminate the filibuster, you'll be in bad shape. We won't pass any legislation. There'll be no legislation passed for 3.25. We have 3.25 years, so that's a long time. But when they can't do an extension, and John, I think they've done an extension every single time they've ever been asked forever. This is the first time they haven't done an extension. Extensions are supposed to be easy, but if they won't do an extension, they won't do any bill, even a simple bill. And we should do our own bills. We should get out. We should do our own bills. We should open up. We should start tonight with the country's open. Congratulations. Then we should pass voter ID. We should pass no mail-in voting. We should pass all the things that we want to pass, make our elections secure and safe.
And if you'd like to continue watching that, again, that's the president at the White House with Republican senators, and we have live coverage of that over on C-SPAN 2. Here we will continue our conversation about the Supreme Court case on tariffs, and we'll talk to David in Palm Beach County, Florida, Democrat. Good morning, David.
Good morning. I had to listen to the irrational statements by the president. From a more practical perspective, most Americans now see the Supreme Court as simply unwilling to deny President Trump anything, any power whatsoever. And that's, of course, concern. But when the government was formed almost 250 years ago, Congress was created to be the representative, if you will, the voice of the people. It was not created to be what it has become, the voice of the president. And I'm talking about the leadership in the Senate and the House of Representatives being Republicans. They are the voice of the president and not the voice of the people, which has got to be concerning because we have a president who's been misleading Americans continuously about where the revenue from these tariffs is coming from. Many Americans believe that we are punishing the foreign countries by making them pay. They're not paying. And it's been used, the term tax has been used, but what this is a punishment to the American businesses and American individuals that they don't seem to realize. And I can't tell whether this is being done to offset the tax benefits or the tax reduction that was enacted into law to offset the loss of revenue, or there's some other reason for doing it. But it's certainly not helpful to the American who now has to pay more for nearly every good that's imported, and even some of the goods that are manufactured in this country, but with the aid of imported material.
All right, David. Jonathan Adler, your comments on that.
Well, I think to focus here, we should recognize that the court has a long history of policing the executive branch. In the first administration, first Trump administration, it had the worst record in the Supreme Court of any modern administration. In the second administration, this is the first case in which the court is actually being asked to evaluate a Trump administration action on the merits. And I think we'll see, not just in this case, but in a large number of cases over the next several years, whether or not the court continues to apply doctrine in a way that constrains the scope of delegations to the executive branch. And just to return to a point that was raised earlier, it's certainly true that tariffs can be used for regulatory purposes. But when Congress has delegated that authority to the executive branch, it has always done so subject to constraints. This goes all the way back to the founding period. Now, there was a long period of time when the power to impose tariffs was generally not delegated at all. But even once it was delegated, it was always subject to significant constraints. And current law even includes the authorization of tariffs for some of the purposes that President Trump is asserting now, such as to deal with persistent trade deficits. But that power is subject to constraints in a way that IEEPA is not. And so a real question for the court is whether or not it's going to allow IEEPA to be used by the president to circumvent all of the other constraints and limitations that are placed on the tariff power in the other statutes that Congress has enacted.
Here's Mustafa in Philadelphia, Republican. Good morning.
Yes, good morning. Am I on the air?
Yes, you are. Go right ahead.
Well, I think the Supreme Court's ruling really reinforces something important, that the president needs the room to act when it comes to protecting American industries. What President Trump did with the tariffs wasn't about picking the fights. It was about leveling the playing field and standing up for American workers who have been losing out for years. So the court's decision confirms the kind of action is within the president's authority. And honestly, I think most Americans want that strong leadership that puts our economy and our people first. And this is my only comment, and thank you very much.
And Jonathan, your response to the concept of the president protecting American manufacturing through these tariffs?
Well, I'd say 2 points. I mean, first, as a practical matter, the idea that tariffs actually protect American manufacturing and help it is contradicted by what we see empirically. Most American manufacturers rely upon international trade, both importation and exportation, for their business. So, for example, when you impose tariffs on steel, you make it more expensive for American manufacturers to make things with steel. So tariffs actually don't help American manufacturing. There's no evidence that these tariffs are helping that. But even if one would disagree with that, Congress has in other statutes like Section 122, Section 232, Section 201, given the president specific authority to impose tariffs for certain various purposes, including purposes that are aimed at helping things economically in the country. And the president has the authority to impose tariffs under those statutes. What's different is all of those statutes impose limitations and constraints on both the process that the president and the executive branch must follow and the way in which those tariffs are imposed. What the president is claiming here is that IEEPA can be used to circumvent this finely reticulated system of tariff authority, circumvent the systematic and unbroken practice of Congress being very careful and limited in the way it confers tariff authority onto the president. And so the question is really whether or not all of that can be swept away because the president has declared a national emergency. And that's really a dramatic step and really isn't about whether or not measures can be taken to impose tariffs, whether or not measures can be taken to protect particular industries. It's whether or not this statute can be used in this broad and unprecedented way.
Chad, your response to that?
Yeah, so Professor Adler has mentioned that there are other tariff statutes that give the president different tariff authority, but this case is not about those other statutes. This case is about IEEPA, and it makes perfect sense for Congress when developing a broad tariff statutory regime to give the president some non-emergency tariff authority and to give the president a special emergency tariff authority. And it makes no sense to require the president to say, I've identified an emergency, but now I have to slog through all the procedural constraints of the other non-emergency statutes. Here, the president has declared emergency authority, so as long as the president satisfies IEEPA's statutory constraints, then the president has the authority to use the IEEPA statute.
Here's Alex in New York, line for Democrats. Good morning.
Good morning. My question, well, my rather comment is, how can any Republican think that the founding fathers had in mind that a president like Trump can actually just slap a 50% tariff on Brazil because he didn't like what the Supreme Court did when they sentenced Bolsonaro for their own January 6th? How can anybody say that that is what the founding fathers meant for a president to have that power when he did it so arbitrarily? And it was just off the top of his head. How can that be? How can anyone look at that and say that that's what we meant?
Okay, Chad.
Well, the founding fathers understood that tariffs could be used to protect domestic manufacturing. Alexander Hamilton is kind of the biggest champion of this at the founding era. And it's important to know that as a legal matter, these tariffs are being blessed, approved of by Congress. The president is using congressionally enacted statutory authority. So Congress gave the president this IEEPA authority. And the statute says that Congress could always override the underlying presidential declarations if Congress wants to. Congress has tried this last week. There's not the votes apparently to do that. So the kind of political, for kind of a business clients to come into the Supreme Court and say, the politically elected president of the United States has made this call. There's not a political will in the elected Congress to override it, but we want you, the court, to override this very factual emergency declaration. I don't think that the court is going to find much appetite in doing that.
But the caller did mention those Brazil tariffs as a result of domestic politics in Brazil. How can that be considered an emergency?
Yeah. My understanding is that this case is not about those Brazil tariffs. I actually haven't seen any of the legal presidential memoranda and things of that nature defending those Brazil tariffs. This case is about the drug trafficking tariffs and the reciprocal tariffs.
Do you expect more court cases to come about?
I suppose.
Or you think this is going to be it?
It depends how the court rules, I suppose, yeah. But there could always be different challenges to different tariffs, yeah.
Let's talk to Steve in Louisiana, Republican. Hi, Steve.
Good morning. Good morning. Yes. The tariffs are intended to protect American manufacturing of products that we're trying to sell overseas. And the proof in that is we have been depleting our manufacturing base for the last 40 years at least. And the results of that is look at the condition of Detroit, Pittsburgh, Lansing, Michigan, Cleveland, Ohio. We have lost our manufacturing base to foreign countries for decades.
Jonathan Adler, your response to that?
Well, again, I don't think one can look at the lack of tariffs as the cause of the decline in manufacturing. There are a lot of other broader systemic factors that influence that. And as I noted before, American manufacturers rely very heavily upon the ability to import materials, import the things that they need to put into their products and use to make their products. And these tariffs, among others, make it harder and more expensive for them to do so. And certainly what we've seen thus far with these tariffs being imposed, that is the effect. But in terms of the broader question, as a policy matter, if we want tariffs, again, there is no precedent for using IEEPA or any of its predecessors in this way. For the first over 100 years of this country, Congress was very jealous about giving away the tariff power, delegated authority to impose tariffs very narrowly and subject to tremendous constraints. Even during the Civil War, Congress did not give the president blanket authority to impose tariffs. What the president is claiming here is the ability to use a statute that has never been used in this sort of way to impose tariffs not against a specific country due to a specific emergency that was unforeseen and unexpected, but rather to use this statute to literally remake trade relations with every country on the face of the earth. That is not an emergency of the sort that Congress was focused on. It is not the way this or any of its predecessors have ever been used. And it is directly contrary to the persistent practice of the first over 100 years of this nation, where Congress gave only very narrow authority to the executive branch to make determinations about what sorts of tariffs would be imposed. And so even when tariffs were used for regulatory purposes, Congress has traditionally been very restrained in the delegation of that power.
I want to play for you a portion of Treasury Secretary Scott Bessent. He was on Fox Business last week, and he talked about the tariffs and this case, and then I'll get your reaction.
The revenue has been very helpful in terms of we had a lower deficit this year, not by much, from the big mess that we were left with the Biden administration. But just think about what's happened over the past months and the past weeks. If we are able to solve this fentanyl crisis, then it will have been because of the president invoking IEEPA, which is an emergency authority. If the fentanyl crisis is not an emergency, I don't know what is. When the Chinese on October 8th threatened to put, here, and think about this, when the Chinese on October 8th threatened to put on these global export controls on rare earth magnets that could have shut down our industrial base, the industrial base of the world, the president was able to exercise just the threat of 100% tariffs to negotiate with, and the idea that that negotiating leverage could be taken away from the President of the United States. Because I tell you, it would have been a mess if this rare earth regime had gone in, could have caused substantial single digits decline in GDP, massive job losses across the country. So I am sure that Scotus will take this into account as they are doing this. The president has used the powers judiciously and in an emergency situation to help the people and the economy of the United States of America, which is why they were designed.
So Treasury Secretary Chad Squateri, what do you think of that?
Yeah, I think as far as the geopolitical landscape goes, it's incredibly good timing for the president for argument to be this week. The president was, of course, just abroad, negotiated tariffs effectively with the leader of China. I think that just goes to show that these tariffs are a pretty important presidential foreign policy tool that the court, I think, is going to be hesitant to get in the middle of.
Jonathan Adler, your reaction?
Yeah, I mean, I think we're really forgetting the broader constitutional structure here. If the president wants to enter into a treaty with another country, that treaty has to be ratified by the Senate. The president does not have the unilateral authority and has never had the unilateral authority to bind the nation in agreements with other countries without the participation of the legislative branch. Historically, if Congress has wanted to give the president that sort of authority to negotiate trade agreements, it can do things like enact fast-track trade negotiation authority, which has often been done to allow the president more unilateral authority. So there are ways of doing this sort of thing. But what is being asserted here is to take this one statute and this one power that has been used in very narrow, discrete ways throughout its history, and use this as the source of all trade authority, all authority over the imposition of tariffs, and this kind of one kind of universal tool for foreign policy. That's clearly not what Congress ever delegated. It's not clear that Congress could delegate that sort of authority. And to assert that the president can or should exercise that sort of authority is really inconsistent with the constitutional structure and the entire history of how these sorts of questions have been dealt with since the nation's founding.
On the Republican line, Chatham, Massachusetts. Mike, you're on the air.
Yes, good morning. I would like the folks there to speak to the difference, putting the legalese aside. The Webster Dictionary says that there's a distinct difference between taxes and tariffs, and I'd like them to speak to that.
Jonathan Adler, why don't you take that? The difference between taxes and tariffs.
Well, I don't think that really matters here. The language in the Constitution speaks of duties and excises and taxes together, and the power that it's the first power listed in Article 1, Section 8. So the fact that tariff and tax are in a modern dictionary viewed differently doesn't really matter. The way a tariff is imposed, the way that the government actually imposes one, is to require the individual or firm who is importing something to pay a fee to the United States government for the privilege of importing that thing. So if I'm, say, a manufacturer of tractors and I want to import rubber for the tires or import steel to build a tractor, I'm the one that pays the tariff, not the country or the firm that produced the initial steel or rubber and is sending it to me. And whether we want to use the word tax to describe that or not, the function, the way that actually acts in practice, is that I, the importer, am paying the government for importing. And if we don't want to call a payment to the government by an American citizen or a firm a tax, it's still going to operate as a tax. It's still going to have the economic effects as a tax.
Angela in Sylmar, California, Independent Line. Good morning, Angela.
Good morning. I wanted to ask the question, is the tariffs the same as what happened with the Boston Tea Party? And also, why are we putting so much tariffs on China when it looked like 80% of our products, such as our clothes, our shoes, our electronics, are coming out of China, and we're no longer manufacturing it in the United States? Thank you.
Yeah, so great question. As I mentioned a little bit earlier, the revolutionary pamphleteers, some of those Tea Party individuals, made a clear distinction between taxation and commerce regulating tariffs. If you look at the historical record, they say no taxation without representation, but by the way, commerce regulating tariffs are distinct. And I want to circle back to a point Professor Adler made, because he said that perhaps it doesn't really matter about the distinction between taxes and tariffs. I strongly disagree with that. It is crucial to this case, and I think that's kind of the soft underbelly of the challengers' argument. They insist that tariffs always have to flow from the taxation clause. That is wrong. The historical record on it is overwhelming. Tariffs can flow from the taxation clause, but they can also flow from the Foreign Commerce Authority. James Madison, Joseph Story, Chief Justice Marshall, on and on. That authority can be more easily delegated to the president. So when Professor Adler is saying, well, historically, when Congress gives certain powers to do tariff, they use different language. Okay, sure, but this is a special statute that gives the president special emergency authority in the foreign affairs context, the height of presidential power. So we have to be, I think, pretty particular about where in the Constitution this authority is coming from and what statute the president is claiming.
Gene in Benton Harbor, Michigan, Democrat, you're on the air.
Morning.
Morning.
These tariffs, a gentleman had it right earlier. They're a tax on us buying goods to replace the money that's been given back to the billionaires and millionaires. And the fentanyl accusation of these, emergency powers is just fake. 100,000 people or so, they said, were dying of these tariffs. That number was going down. And I dare say that a lot of these people that are dying from fentanyl know exactly what they're using and that they could die. They want the drug.
Jonathan Adler.
Well, I mean, whether or not or what causes people to use fentanyl, I think is a separate question. I think the idea that these tariffs are first of all, replacing the money that comes from loss of revenues in other places. I don't think we've seen that yet. The brief filed by the Solicitor General talks about trillions of dollars in revenue, but I think the actual record thus far is the tariffs have not even brought in $200 billion yet in revenue, so they're not going to finance the government. And again, the broader point is whether or not we see or recognize tariffs as being able to be used for purposes other than raising revenue. The way they function is to impose a tax. And throughout history, whatever purpose they've ever been used for, Congress has always been very narrow and discreet in the way it has delegated this authority. Through most of our nation's history, did not delegate the president the unilateral authority to impose tariffs. And under current law, only delegates that authority subject to very specific constraints. And so we have multiple statutes that make express and distinct reference to the use of tariffs for various purposes, including the purpose of addressing trade deficits, and require the president to do certain things in that context. And what is being asserted here is the ability to use another statute to sweep all of that away for all of our trade relations. So it's really a breathtaking, unprecedented assertion of authority, and whether or not it's concerns about fentanyl or concerns about what China is or is not producing, that's not the sort of authority that Congress delegated under IEEPA. And the question is whether the Supreme Court is going to recognize that.
Chad Scotteri, what do you think are the possible outcomes of this case?
There's a few different paths I suppose the court can take. One, they can rule that the statute grants the president tariff authority, which I agree with, and that's constitutional, which is what I think the court should rule. They could argue that, or they could rule that the statute gives the president tariff authority, but it's unconstitutional. Or they could argue that the statute doesn't give the president the tariff authority.
And are there, if the Supreme Court were to take one of those other routes of saying that this is either unconstitutional or does not give him that authority, what are the administration's options at that point?
It would be very dependent on what sort of remedy the court grants. I could imagine there being challenges about the authority for the court to issue, I suppose, unappropriated funds to various importers and exporters. So I think it could be caught up in perhaps years of litigation, but it would be very dependent on the precise remedy that the court grants.
So the court could say you have to pay everybody back.
They could rule that, yes, and I think that could lead to complex litigation on the back end.
Let's talk to Jake in Mississippi, line for Republicans.
Good morning. Thank you all for having this conversation this morning. My question was in regards to how y'all think that the Morrison v. Olson case may affect the Supreme Court's ruling in this case, in the sense that Congress was able to take a specific power that was directly given to the executive branch under the Constitution. Wouldn't the court then say, well, this is a case in which Congress gave up a power of their own to the president, and just because people are upset with how he's wielding that power doesn't mean that they should then reverse the decision which they've already made in Morrison v. Olson?
Jonathan Adler, what do you think?
I'm not sure Morrison versus Olson is the relevant precedent here, but certainly the question is what sort of power did Congress give to the president and what are the bounds of that power? And I think that's really what the court is going to focus on. I do think in terms of the nature of executive power, there is this kind of sub-argument about whether or not the court should view delegations directly to the president differently than it views delegations to agencies within the executive branch. That is an argument that's been made. I suspect the court's not going to make much of that in the end. But really what this case is about is what is the scope of the power that Congress has delegated to the president. Let me just note in terms of remedies, there is a well-established and operable administrative process for the refund of unlawfully imposed tariffs. So whatever happens in this case, sometimes tariffs are imposed accidentally in an unlawful way. Sometimes other sorts of tariffs can be invalidated or modified through litigation in the Court of International Trade or elsewhere. There's a process that is well established that importers go through if they want to seek refunds for a tariff that was improperly imposed. So there's really no need for any broader alternative remedy in this particular case because there's already an administrative structure to deal with refunds if refunds are necessary.
Here's Rob in Kansas City, Missouri, Democrat. Good morning, Rob.
Good morning. Real quickly, so all tariffs, in my opinion, are born out of bluster and frustration, and they are not born from thought, economic, sound policy. And there's no daylight between Smoot-Hawley and Trump tariffs. Herbert Hoover really tanked this country because of that reason and others. Secondly, I think that the Supreme Court can save Trump by overruling his tariffs because even his own party doesn't care for it. And thirdly, it's a gift for the Democrats because their message is now affordability as of last night. And guess what? Tariffs don't create affordability across the country. So I think this is working really well for the Democratic Party, and I'm quite happy about it. Thank you.
Chad.
Yeah, well, I think the caller raises a policy objection to tariffs, but under the structure of our Constitution and this statute in particular, that policy decision is to be made by the president, not law professors, not economists, and things of that nature.
And Jonathan Adler, I give you the last word on this.
Well, I mean, I think there's a broad consensus that these tariffs have not produced the policy benefits that were hoped for. But where I think Chad and I would agree is that the question before the court is not whether or not tariffs are a good idea, or whether generally, or whether these tariffs are a good idea, but whether Congress in this statute delegated this particular sort of authority to the president. And that's an important legal question. And generally, the court's going to focus on that legal aspects of a question like that, and not on the policy implications or on which political party it might benefit.
That's Jonathan Adler, professor at the William & Mary University Law School. Also with us, Chad Squateri, the Catholic University of America School of Law professor. Thank you both for joining us today.
Thanks for having me.
Thank you.
Up next, more of your phone calls after the break on today's Supreme Court case on President Trump's tariffs. We'll also hear your comments on the government shutdown, now officially the longest in history at 36 days, and the elections yesterday. If you'd like to weigh in on that, you can start calling now. Democrats are on 202-748-8000, Republicans 202-748-8001, and Independents 202-748-8002. We'll get to your calls right after the break.
Watch America's Book Club, C-SPAN's bold new original series, this Sunday with our guest, the chronicler of adventures, award-winning best-selling author David Grann, whose books include The Lost City of Z, Killers of the Flower Moon, and The Wager. He joins our host, renowned author and civic leader David Rubenstein.
So what about this fact, about this occurrence, made you think this could be something worth your time?
And I started to realize that this odd little old manuscript contained, the seeds of one of the most extraordinary stories of survival and mayhem I had ever come across.
Watch America's Book Club with David Grann, this Sunday at 6 p.m. and 9 p.m. Eastern and Pacific, only on C-SPAN.
Friday on C-SPAN's Ceasefire. At a moment of deep division in Washington, former Democratic National Committee Chair Donna Brazile and former Republican National Committee Chair Ronna McDaniel come together for a bipartisan dialogue on Tuesday's election results, potential impact on the 2026 midterms, and increasing partisanship. They join host Dasha Burns.
Ceasefire, bridging the divide in American politics.
Watch Ceasefire Friday at 7 p.m. and 10 p.m. Eastern and Pacific, only on C-SPAN.
Today, watch live as the U.S. Supreme Court hears oral argument in the landmark case on President Trump's tariff policy. The case reaches the High Court after the president appealed lower court rulings that struck down his Liberation Day tariffs. Coverage begins at 8 a.m. Eastern on Washington Journal, with Scotus blog reporter Amy Howe providing key insight, legal context, and analysis while taking your calls and messages. And then at 10 a.m. Eastern, join us for live, unfiltered, uninterrupted audio of the oral argument from the U.S. Supreme Court on C-SPAN. You can also follow along at cspan.org, where we'll feature live blogging in partnership with Scotus blog, offering real-time analysis of the lawyers' arguments and the justices' questions. After the hearing, stay with C-SPAN for a roundup discussion and viewer reactions. Live coverage of the U.S. Supreme Court's Trump tariff case. Today, starting at 8 a.m. Eastern on C-SPAN, on the free C-SPAN Now video app, or online at cspan.org. C-SPAN, bringing you democracy unfiltered.
Washington Journal continues.
Welcome back to Washington Journal. We are taking your calls on the three big news stories happening in Washington, one of them being the election results yesterday. We're on day 36 of the government shutdown, longest in history. And of course, that Supreme Court tariffs case gets underway in about an hour. And we've got C-SPAN cameras outside of the Supreme Court talking to people that are lined up to try to get in. And C-SPAN's Tammy Thuringer is out there. We will, Tammy, you there?
Hi, good morning, Mimi. We are out here. There is a smaller than usual line because of a lottery system the Supreme Court now has in place, but there are still a lot of dedicated people hoping to get in to hear that case. And one of them, toward the front of the line, I believe he was number 3 to get in, is Vikram. Vikram, good morning. Thanks for being with us.
Good morning. It's nice to talk to you.
And tell us why you're out here today.
Well, this is a really major case. I think as the president truthed like last night, I think it has major implications for how our nation goes forwards. I think it's more about the separation of powers than the trade deficit, but it's a super important case regardless. And I've been to the Supreme Court before, and I try to go to as many major cases as I can.
And you said you've been to 6 cases now. Why the interest in this one today? How do you think it's going to compare to some of the others you've seen?
So some other cases, I was at like the TikTok and Scrimeti cases, and they were pretty important, but I felt like they implicated less the separation of powers between like the president and Congress, because ultimately it was about like individual rights or state law, or like in TikTok, a law that both the president and Congress had enacted. But here it's really about can the president, unilaterally enact what I think are basically taxes on the American people without Congress. So I think that's what kind of makes it super important in my mind. But I think they were all very important cases.
And you do have a sign, a paper that says number 3. You've been out here since yesterday. What time did you get here? And explain your brief departure.
Yeah, so I got here at around 3:30 p.m. yesterday because I know they give out fewer tickets now because of a lottery. So I wanted to be sure. But I had my mergers and acquisitions accounting midterm from 6:30 to 9:30. So I went back to Georgetown for that, and someone was nice enough to hold the line for me while I did that. And then I came back at around 10:15, and I've been here since. I got a little bit of sleep, but yeah.
You like going to the court cases. You've obviously been here a few times. You mentioned you wanted to go to law school. You're an undergrad right now. What area do you hope to study? Why do you find law so interesting?
Well, I guess I find law interesting because it's like society has tried to rationally come up with rules to govern itself. And I guess that act of self-governance is like a really high fulfillment of human potential in my mind. So I guess like philosophically, that's why I like law. I've been interested in it since like 8th grade. I'd hope to practice some sort of like public interest litigation. I think like directly challenging when rights and like the structural separation of powers are imperiled as an individual is super important, and that we should do more of it. We don't have enough public interest lawyers.
And you have been here several times. What does it mean to go inside and actually see the cases in person versus listening to them stream, which you also do?
Yeah, so I do listen to some of the live streams, but I think you do get something extra by seeing the justices' faces and like the cadence of the argument in person. I don't know how to really describe it, but I think one good example is when I was at Scrimeti, one of like the key questions that was swirling around is what Justice Gorsuch was going to do, because he wrote the court's opinion in Bostock, which extended Title VII to protect transgender people and homosexual people. But he stayed silent the whole argument. However, if from inside the courtroom, I could see that he actually had a long conversation with Justice Barrett while the argument was going on, and you could tell they were like nodding to each other and agreeing. So I felt like I knew Gorsuch was going to come out in favor of Tennessee in that case because of what Barrett had written previously, and it seems like they agreed. And yeah, Barrett ended up writing a concurrence. They both voted for the state.
And because you've been in so many times, hopefully you get in today, but what advice do you have for people who do want to see a case in the future?
I would say that if you want to go to a major case, you should be prepared to stay the night, but that there are a lot of lesser recognized cases where you can still get into the court and experience what an argument is like without having to go through the whole hassle. So like I went to one like pretty boring patent case. I confess I remember none of the facts from that case, but the line didn't fill up until like 5:30 a.m. So you could have actually gotten some sleep and attended that one.
Well, Vikram, thank you so much for your time this morning and talking with us.
Yeah, thank you.
And we are back to our calls. We'll go to Daniel in Forest, Virginia, Independent Line. Hi, Daniel.
Hi. So with tariffs, I do understand that they are to some extent imposing a tax, but I feel like that's largely overstated, and the main people who are going to get hurt by it are people who have sold out America's interest to produce cheaper elsewhere, and that the main companies that are going to really hurt are the people that have invested heavily into offshoring a lot of production. And the companies that have stayed in America or have reshored recently are probably going to do well.
All right, Daniel, let's talk to Howard next, North Carolina Democrat. Hi, Howard.
Hey, top of the morning to you guys. Hey, look, I said this around the 1st of October when the shutdown was going, and I'd like to say it again. Don't you guys remember when the Democrats had it and Vice President Harris was the tiebreaker? It was 50-50 in the chamber. All they needed 51. Now, we was in the process of doing the nuclear to get rid of the filibuster because we believe in the John Lewis Voting Rights Act. We believed in the George Floyd Act, and we believed in the Civil Rights Act. So the Republicans wasn't going to come along with it, so we decided to do the nuclear. But Manchin and Sinema went over and blocked it. Now, people say, oh, you can't do that. That's open the Pandora box. But American people, you got to understand, when you got people in there that's trying to block you from prosperity, somebody need to do the nuclear. You remember?
So are you in favor of it now, Howard?
Oh, yeah, most definitely. But see, the Republicans is not going to do it regardless. Even Trump trying to play the role like do the nuclear. No, they're not going to do it because Trump don't want them to do it. This is something between the Republicans now. Mitch McConnell did it twice. Right? And they put it right back on. It takes 51 to take it off, and it takes 51 to put it back on. And they can start this all over again. But if they open up the government, we would get the Epstein files. They'd rather scorch earth than to put their name out of being a pedophile. This is what it's all about, people. It's not about you. It's about them keeping their names closed in them files.
All right, Howard. Here's Frank in Washington, D.C., Republican. Hi, Frank.
Hey, thanks for taking my call. You know, my concern with Mayor-elect Madani in New York is his approach to subsidies and his ongoing push for government assistance. You know, there's a principle you see in national parks, right? Do not feed the wildlife. And the reason is that when something becomes dependent on being fed, it can lose that ability or incentive to sustain itself. And I think the same thing applies here. If the focus is primarily on handouts instead of building pathways to self-reliance and job skills, education, long-term economic opportunity, we really risk the dependency rather than the empowerment. And I'd really like to see leadership that emphasizes helping people become self-sufficient and not permanently relying on government support. So it'll be really interesting to watch New York City. Thank you.
All right, Frank, and let's take a look at a portion of Zohran Mamdani's acceptance speech from yesterday.
After all, if anyone can show a nation betrayed by Donald Trump how to defeat him, it is the city that gave rise to him. And if there is any way to terrify a despot, it is by dismantling the very conditions that allowed him to accumulate power. This is not only how we stop Trump, it's how we stop the next one. So, Donald Trump, since I know you're watching, I have 4 words for you. Turn the volume up. We will hold bad landlords to account because the Donald Trumps of our city have grown far too comfortable taking advantage of their tenants. We will put an end to the culture of corruption that has allowed billionaires like Trump to evade taxation and exploit tax breaks. We will stand alongside unions and expand labor protections because we know, just as Donald Trump does, that when working people have iron ironclad rights, the bosses who seek to extort them become very small indeed. New York will remain a city of immigrants, a city built by immigrants, powered by immigrants, and as of tonight, led by an immigrant.
That was Mayor-elect Zohran Mamdani of New York City. You can listen to the entire acceptance speech, as well as all the acceptance speeches and the concession speeches from yesterday at our website, cspan.org/election2025. Starting momentarily, the Senate Democrats will be holding a news conference outside on the Capitol steps. We'll have coverage of that at C-SPAN 2. You'll hear from the ranking Democrat on the Senate Small Business Committee. That's Ed Markey of Massachusetts. And he and his Democratic colleagues will be arguing that tariffs hurt small businesses and will call on the Supreme Court to strike them down. You can watch that at C-SPAN 2 on cspan.org and on the app C-SPAN Now. Here is Craig, Columbia, South Carolina, Independent. Good morning, Craig.
Hey, good morning. Thank you for taking the call. You know, there's chat about the Supreme Court, but if you go way higher up the ladder, the dear Lord has given us instruction in Proverbs. If you support anybody that oppresses poor people, and dear Mr. Trump hates Hispanic people, you will only come to poverty. Solomon wrote that. Here in South Carolina, folks love Donald Trump. And what they're going to see in the near future is their health insurance is going to triple. And that's going to hit this state incredibly hard, and the hospitals. The other thing is the Bible says you can always tell people by the fruit they bear. And what follows Trump is usually chaos. If you chat about economics, I was blessed to go to school in Switzerland when I was a kid. If you think the world is impressed with Trump's tariffs, tell me the price of an ounce of gold today. I bought gold kind of as a kid at $3.24 and $3.48 an ounce, and right now it's over $4,000. But I thought I'd throw that out. You don't beat the Lord. Angry people create strife. Beyond that, furious people look at you, but inside they're just churning. They have oodles of transgressions or abound in transgressions.
All right, Craig. And we'll take a look at the Senate Democrats that are outside of the Capitol right now talking about small businesses and the Supreme Court case.
This case will affect every American and the 36 million small businesses in our country. This case is not enemies of the state versus Trump. It is small businesses versus Trump. It is Main Street versus Mar-a-Lago. And it is mom and pop versus Trump's billionaire buddies. That is what is going to be heard before the Supreme Court of the United States today. Small businesses are the ones leading the charge to overturn Trump's illegal tariffs. Small business owners will not allow Trump to destroy all that they have worked for. When it comes to trade, small businesses make up 97% of all importers and exporters in our country, and it accounts for 1/3 of all American trade. Small businesses like those standing behind me today are not big companies. They cannot buy a year or two of inventory for a rainy day. Small businesses work week to week, month to month. They struggle to survive. And this threat that is being posed by the Trump tariffs on small businesses is an existential threat to their ability to survive. Because small businesses...
That's the top Senate Democrat on the Small Business Committee. That's Ed Markey of Massachusetts. Let's go back over to the Supreme Court and talk to C-SPAN's Tammy Thuringer. speaking to people lined up.
Hi, Mimi. You've been talking with people there in the studio, breaking down the case that is happening today. Happen to have the daughter of the plaintiff in the VOS election, the Trump case. Chloe is out here with me. Chloe, thanks for talking with us this morning.
Thank you for having me.
So you're in a very unique position. Your dad is inside the court. He's a plaintiff. He filed this original case. Tell us about why he moved forward with it.
This goes back to Article 1 of the Constitution, why the revolution was fought. No taxation without representation. We are asking for, if there are going to be tariffs, they need to be passed on the Capitol and not by this administration.
And you are out here, again, your dad is inside. We hope you get inside. Hopefully you move your way down the line. What time did you get here and why did you want to be inside today?
So these tariffs present an existential threat to my family business, which I hope to take over one day from my father. I got here at 3:30 this morning, so I'm hoping to get inside so that I can see this landmark case that affects not just my business, but American businesses.
And tell us a little bit about the process. You said this is your first time here at the Supreme Court, but of course you've been there for all the lower cases as it's worked its way up to where we are now. What have you experienced during that, and what do you hope to see today?
Just the tremendous outpouring of support, not just from American business owners, but internationally. There's been incredible support, and it just feels like we have a strong network of strength here. All of the amicus briefs, all of the support from all sides of the aisle. This is not about politics. This is simply about the Constitution and upholding the law.
Chloe, thank you so much for your time.
Back to the calls now to Francesca in Alexandria, Virginia, Democrat. Good morning.
Good morning. I am very proud of the Democrats last night. I think it really defined what the Democratic Party stands for. We are a party that addresses the needs of a diverse population. We are diverse in all of our attempts to hire people of many backgrounds. The people came out for affordability, but they also came out for democracy. And young people came out, people who voted for Trump came out who were disappointed by his cruelty and his incompetence of lowering costs as he promised. Finally, we voted down Republicans who only mimic him and bow to his commands and don't represent them. We represent the people and we listen to the people.
So, Francesca, President Trump has said that Democrats won yesterday because of the government shutdown. Do you agree with that? What do you think the impact of that shutdown was?
I think the impact of the shutdown showed how cruel this president is. People who are affected, I have a friend who is working furloughed without pay, who has children to support, a mortgage to pay. And so these people, these hard-working people came out because they are being treated like animals. They're not respected. The Republican Party has just succumbed to this cruelty and this nonsense of a president who is just creating chaos in our country. I mean, when he tore down the East Wing, he tore down the symbol of our democracy. I mean, this is not normal. His behavior is not normal, and people know that.
All right, Francesca, and let's go to Sean, a Republican in Steubenville, Ohio. Good morning, Sean.
Yes, thank you for having me on. I think these tariffs are more important than anybody really imagines. You know, the effective tariff rate around the world is basically 18%, besides China, of course. But I live in a steel mill town. There used to be 3 steel mills here. They're all gone. They went to China years ago. The only way we're going to get these industries back is by putting tariffs, unless you make your product here, and then there is no tariff. People seem to forget that Canada had a 300% tariff on dairy against us. EU has all kinds of tariffs and VAT taxes on us. It's about time we get our trade situation squared up here. And Gerald Ford, he used tariffs in '75 with his the Tariff Act, Free Trade Act. it's about time we've had a president to do something to try to get industry back in this country.
All right, Sean. And this is Jonathan in Glen Cove, New York, Independent Line. Good morning.
Good morning. Under ordinary circumstances, it's illegal for someone to break down your door and enter your house without your permission. But if there's a fire, the fire department gets emergency powers. They're allowed to break down your door and enter your house in order to deal with the emergency. But they only get those powers if there's a real emergency. If you came home and you found your door broken down and a bunch of people hanging out in your living room, and they just said, well, we're from the fire department, there was a big fire here, and you look around and there's clearly no fire, that does not mean they have the right to be there. The fact that they're willing to lie does not grant them emergency powers.
So you're talking about the trade deficit and the fentanyl issue being the issue for the Supreme Court case. Is that what you're talking about, Jonathan?
Yes, yes. The president is claiming that he has these emergency powers, but there's no emergency. Right? The fact that this president's word is absolutely worthless.
So, Jonathan, respond to the caller right before you that talked about American manufacturing and that the only way that we're going to bring that back is through these tariffs. What do you think of that?
Okay, well, if we want to bring back the manufacturing of the 19th century, then yes, tariffs are the way to do that. If we want to bring, if we want to have jobs for a 21st century economy that's going to, actually work for us, give us good paying, clean jobs, that don't give our workers black lungs and stuff like that, then tariffs are not going to do that. I mean, this country was basically founded on the Enlightenment. One of the people the founders really looked at was Adam Smith and the Wealth of Nations, and he makes a compelling argument that tariffs are damaging to economies and to growth and to invention.
All right, let's talk to John, Syracuse, New York, Democrat. Good morning.
Well, I don't think tariffs are popular. You get two different opinions. Some people are calling and saying they're good. Some people say they're not. As far as manufacturing, but basically he's trying to get manufacturing to come back to America. Good paying jobs, I agree with. Get them back here. But there's a lot of this manufacturing, like sneakers, clothes, and stuff. They can do it cheaper, where they can do it in other countries because they don't pay good wages. So you can get a pair of sneakers at half the price that you would buy it if they were made in America. They'd be twice as expensive if they were made in America as compared to China or Vietnam. So as far as manufacturing coming back, I don't know. I support good jobs coming back, but a lot of this manufacturing, it's not going to they're low-paying jobs. So, and as far as the election results, I hope the Democrats don't think that this is a mandate for caravans of illegal aliens coming in here, because to me it was about the economy. It wasn't, about immigration or anything else. It's the economy, and the economy does not look good.
All right, John, and let's go check out outside the Supreme Court and talk to some folks standing out there. Here is C-SPAN's Tammy Thuringer.
Hi, Mimi. We just heard from someone who is directly connected to one of the lawsuits that the Supreme Court is hearing today. And with me now is Taylor, who also has a connection. Her clients are being impacted by tariffs. Taylor, thank you for joining us.
Yeah, absolutely. Nice to be out here this morning.
And you drove up here from North Carolina. Explain what you do and why you wanted to be here today.
Yeah, so I am a U.S. customs broker, been in this industry for a little over 4 years, and really just came today to not only learn more, but hopefully get some clarity and insight into how all of this is going to play out. Definitely as a customs broker, we're helping clients estimate their duty, make sure they're meeting import compliance regulations. So our day today has been very chaotic in 2025 with all the changes.
And you were sharing with me how your clients are being impacted. Explain to our audience what it's been like with the tariffs and how this Supreme Court case, one way or the other, however it's decided, could impact them.
So along with the obvious really significant increases in the tariff costs that our clients are having to shoulder, it's been really impossible to do any strategic supply chain planning with the constant changes. On top of that, there's usually not been a lot of time to really plan, so you've got one shipment on the water expecting to pay a certain amount of duty, and then by the time it ends up in the U.S. ports, you're suddenly paying a much significant higher tariff.
And you are unfortunately back toward the end of the line. We're not sure if you're going to be able to get in today to actually see the case play out. If you are, what are you hoping to see? What are you hoping to hear from the justices?
So I'm hoping to get more insight on not only the logic behind these tariffs, but it would be great to know if, what we're looking for going into 2026 is going to be, should we expect to continue seeing these chaotic tariff changes that don't come with a lot of advance notice, or is there going to be some hope for the future that our clients are going to be able to have more foresight and planning?
You haven't been in line as long as some of the other folks toward the front, but have you been chatting with other people? What are they feeling about the case and why they're out here today?
Yeah, it seems like everybody has really mixed opinions about it and what the outcome will be. Personally, I really don't know one way or the other. I will say I think, whether the court upholds these tariffs or not, higher duty and higher tariffs are here to stay, at least for the foreseeable future.
Taylor, thank you so much for your time.
And we're getting your thoughts on that Supreme Court case on tariffs, as well as the shutdown or the election results from yesterday's election. Here on the Republican line is in Harrison, Arkansas. Stan, good morning. You're on the air.
Yeah, good morning. I'm calling I got a couple of comments. I think the tariffs and the government shutdown is hurting the country. Myself personally, I'm not getting my EBT, my food stamp money, just like a lot of other people in the country, which I'm lucky that I got Medicaid, Medicare, and WellCare. And on my WellCare card, I can get some medicines and food on the WellCare card, and gas and rent, pay gas, fuel, and pay rent. And one other comment I thought I heard Donald Trump say that no mail-in voting. And I voted for mail-in voting several years back. And how many people in the country are disabled? That's my question. And people that can't get out and vote, if they want to vote, they need to vote.
Yeah, you did hear that just this morning on the remarks that the president made. We dipped in briefly to that at the GOP breakfast this morning at the White House. So he did say that to senators, to Republican senators this morning. But Stan, are you working? What's your situation?
Disabled, and also I'm taking care of my wife. She's disabled, handicapped, and in a wheelchair.
So what are you going to do as far as your SNAP benefits that have not come in?
I'm just going to budget my WellCare money and what cash I have in after I pay bills. As far as getting food for the holidays, like Thanksgiving and Christmas, Thanksgiving coming up. And if the government isn't back up by December, Christmas too. And
do you always vote by mail? Is that how since you're disabled, is that how you vote?
I have before, or I've gone to a voting station and they've come out to the car and brought our ballots out to the car, which I like that. I like that ability to do that. And he needs to backstep on that one as far as no mail-in voting. People should do mail-in voting. Or if they can't get in to vote, go to their polling center and have them bring out the ballots to your vehicle.
All right, Stan. And this is Kelly, Denver, Colorado, independent line. Good morning, Kelly.
How's it going?
Good.
So regarding the last caller, it seems pretty apparent that the president is not in favor of lower income and disabled voters actually having a voice in the election, and he's using his emergency powers and tariffs to hurt the consumer. These are all consumer products that are imported that he's choosing to tariff highly as a revenge strategy against other countries that is harming his own economy.
Okay, and Peter, Gardner, Massachusetts Independent Line. Hi, Peter.
Hello. I just wanted to remind everybody that in this oligarchy, even the losers will win. The Secretary of Commerce, Lutnick, his two sons run an investment organization which has, in fact, bought the rights to tariff money if it is rebated to the people. So they're going to make money if the tariffs are found to be illegal. When the money is returned, they've already paid for that, and they will also win because of the tariffs if the court decides the other way. So here we are in an oligarchy, and we're going to pay no matter who wins.
Here is the the U.S. Senate Committee on Finance. This is what it says. This is August 14th, 2025. Excuse me. Wyden, Warren probe Lutnick firm's potential conflicts of interest related to massive tariff bets. It's following reports that Cantor Fitzgerald, the Wall Street firm once run by Commerce Secretary Lutnick and now run by Lutnick's son, is selling tariff bets. Senators sound alarm over possible conflicts of interest and insider trading. So if you go to finance.senate.gov, you can read that from August 14th. Here is Mary in Cambridge, Maryland, Democrat. Hi, Mary.
Hi, I'm calling in reference to the government shutdown, and also I'd like to know why Trump gave Argentina $20 billion that he could have used for the health care. He's the worst president we ever had. We knew he would do this to us, and he continued to hurt the American people. He's a vicious man, and he needs to get out of the White House after he tore it down.
And Leanne in Pawleys Island, South Carolina, Republican. Good morning.
Good morning. I couldn't disagree more with what I've just heard. Donald Trump is trying to balance what's happened after Joe Biden and
so rebalance what specifically, Leanne? What are the
economy? And it's going to take a little time. And continuing these subsidies over for health care, Obamacare is unaffordable, and it's been proven. So we just continue to pay and pay and pay, and everything keeps going higher and higher and higher. It's unaffordable.
All right, and let's take a look at Senate Majority Leader John Thune. He spoke to reporters yesterday about some possible scenarios on the shutdown.
Mr. Leader, walk us through the play call here, the potential play call here, the idea that there might be some sort of an agreement to move the CR to a later date in January, vote Thursday night, Friday night, something like that. And is there a disagreement between the date between the Senate and the House?
Well, I think obviously, since we are now into November and the CR, we've lost 5 weeks. So the November 21 deadline no longer makes a lot of sense. So clearly it would have to be extended, and there is a conversation around what that next deadline would be. But the hope and expectation would be that we could get appropriations bills on the floor, get them considered and passed, so that we can fund the government through the normal appropriations process. Nobody wants a year-long continuing resolution, least of all the Defense Department, and the best way to avoid that is to move appropriations bills. The date is still something that's being, I would say, being discussed.
And is that because there's an issue in the Senate, or there's disagreement between the Republican leadership in the Senate and the Republican leadership in the House?
It's a function of it's Republicans and Democrats in the House and the Senate. I mean, obviously, you've got to have the votes to execute on whatever it is we put on the floor. And so, we want to make sure that we do that in a way that enables us to have success. And if we have to change the date, which we will, here in the Senate to send something back to the House, we obviously want something that will pass the House and to be signed into law by the President.
And back to your calls now to Kim, Fresno, Texas, Independent Line. Hi, Kim, you're on the air.
Hi, good morning. I just wanted to say, as far as the tariffs go, that people are always saying, okay, we'll bring back the jobs here. Either we bring back the jobs or we get rid of the tariffs. We bring back the jobs here. Well, who sent the jobs away in the first place? The corporations sent the jobs away in the first place. Trump sent his business acumen across seas, overseas because of the cheap labor. So the corporations are sending the jobs away, and now they want to tax us to bring the jobs back here. If they're going to build, they're not going to rebuild steel and coal mines and have things happen here because they have to pay Americans more than they pay people overseas. So they're all on the grift. The corporations, Trump, the administration, everything, they're all on the grift. It's not about saving America through tariffs. It's about putting money in their pockets and continuing to grift America, and that's all I have to say. Thank you.
Norman in Pennsylvania, line for Democrats. Good morning.
Yes, my name is Norm.
Hi, go ahead. You're on the air.
And the lady from Texas has it right. We shipped all the jobs away. I lived it. I sold industrial supplies. I covered the eastern half of Pennsylvania, New Jersey, Delaware, and Maryland. And from 1980 or 1978 till I had my heart attack in 2006. And for the first 3 years, I was knocking them dead, selling like crazy. Then under Reagan, they created a thing called OPIC, Overseas Private Investment Corporation, which told the owners of millions of companies, thousands of companies, that if they want to send their jobs to a third world slave wage nation, they could do it. And if something would happen that would have destroyed that, a revolution or something like that, they would be bailed out by the taxpayers, like we bailed out the Wall Street banks and a couple of big corporations after the 2008 crash. He created OPIC, Overseas Protection Investment Corporation, a division within the Department of Commerce, and we gave it away. And for 28 years, 25 of those years, I saw the market shrink as everything went to Mexico and China. Most of it wound up in China, and it took. That was 25 years, and that was since 2006. And we did so for 30 years or more. We've been sending all the jobs away, and now we want to get them all back. Well, they're not going to get them back in 2 years.
All right,
and not
Norman,
only that,
got that. And Kevin in Richmond, Virginia, Republican. Good morning, Kevin.
Yes, good morning, C-SPAN. I want us to just think for just a second, not about Trump, but the fact that if we could be watching the Treasury Department the day they sign the check for the net interest cost on the national debt. In 2024, it was $880 billion just on the interest. In 2023, it was $658 billion. So it went from $658 billion to $880 billion. If we could see someone writing a check to pay just the interest. So when Trump says that there's an emergency, he's correct. Now, we've supported other countries applying tariffs to our trade so that it would enhance their health care, their development, their ability to buy our products. And now it's time for those tariffs to come down, and no one wants to reduce those tariffs in other countries. So what does Trump do? He raises our tariffs as a leverage point to get them to rethink holding their tariffs and bring them back down to zero. No tariffs are good, just like all the great thinkers have always said. So regardless if you're
Kevin, do you think that this is just leverage and that President Trump wants to reduce our tariffs as well? In other words, to reduce the tariffs that he is now imposing on other countries?
That's correct.
That this is just temporary, you think?
Yes.
Okay. Vincent, Chicago, Illinois, Independent Line. Good morning.
Oh, good morning, Mimi. Listen, Article 1, Section 8 of the U.S. Constitution has 18 clauses delineating the powers of Congress. Clause 1, to lay and collect taxes. Clause 3, to regulate commerce. You can read Article 2 of the Constitution, deals with executive power. I don't think the word taxes, revenue, borrow, or commerce is even mentioned. Donald Trump is a very smart grifter and a sociopath, and he probably has never read the Constitution. But the Supreme Court doesn't have that excuse. It'll be very interesting to see what they do. That's all I have.
And Paul in Eugene, Oregon, Democrat. Good morning, Paul. Paul in Eugene, Oregon, are you there? I guess not. Well, we'll go back to the Supreme Court now to C-SPAN's Tammy Thuringer to talk to some people there. Hi, Tammy.
Hi, Mimi. I am out here. We have a group. Nobody yet has gone in terms of people who are waiting, who've been waiting here overnight. There's a group of 5 law students behind me. We'll start with Carter. They are down from Pennsylvania. Carter, what school are you at?
We are at Villanova Law.
And you're first-year law students?
Yes. We're all in the same class section together, and 10 a.m.-ish yesterday, our professor said, hey, they're arguing a big case at the Supreme Court tomorrow. Do you guys want to come down? And we're the group was large initially. I think there was about 20 of us that expressed interest and emailed him, and throughout the day it whittled down to the 5 of us here.
And Ava, you were one of them. You all got in the car at midnight to drive down here. What are you hoping to see if you get to be inside today?
Some great oral arguments, some great displays of textualism and things that we've been learning about in class, some rules being played out in court, and seeing how the justices are in the flesh.
And Corolla, you are also part of the group, all of you law students. What is your interest in law? Why do you want to see a Supreme Court case?
I think it's a once-in-a-lifetime opportunity, especially, it's not just in any case. It's a case against a president, and a president that's using power in unprecedented ways. So it's a way to clear up and see what the separation of powers will be and how much influence the president has over, I guess, the Supreme Court. So I think that's important to watch as future legal professionals to see how we will move forward in our profession, how we will interpret law.
And speaking of your professions, you're all first-year law students, no specialties decided yet, but what is your general interest in law and why does the Supreme Court matter?
Yes, ma'am. So I want to be a JAG officer, so I'm just really excited to see what the Supreme Court, how it plays out in real life and get the opportunity. As Corolla said, it's a once-in-a-lifetime opportunity, and yeah.
And for our audience who may not know, explain what a JAG officer is and what you'd be doing.
Okay, so a JAG officer is just a military lawyer, and I'm specifically going to be in the Army.
And you all got in the car at midnight. You drove down here. What time did you get in line? And is it going to be worth it whether or not you get in?
I think it was definitely a really interesting experience for sure. We probably got in line around like 2:30, and we've been here just waiting ever since. But I think like it's really exciting to see everything happening. I'm definitely will be a little disappointed if we don't get in, but it's definitely been a fun experience so far. So.
Do any of you listen to the Supreme Court arguments streaming or otherwise? You do. And why do you think it would make a difference to be inside today versus hearing them?
I feel like the energy will definitely be something that you don't get to hear when you're listening to a recording, and also just like the presence of like the justices and like all of the people in the courtroom will be a really cool experience for sure.
And one last question for all of you as aspiring lawyers: do you hope, or would you like to do a trial at the Supreme Court one day?
Yeah, I think that's the ultimate goal for everybody. Yeah, that would be huge.
Well, thank you so much for your time.
Thank you.
Well, we hope all the law students get to get in this morning. We are standing by for about 10 o'clock, where the Supreme Court will start to hear oral arguments. We'll bring that to you here on C-SPAN live. Of course, there are no cameras allowed inside the Supreme Court, so you'll only be able to hear it, but we'll have that for you. Also on our website, cspan.org, we've got a page set aside for the Supreme Court. You can get a lot more information there. Let's talk to Yvonne in Kennesaw, Georgia, Independent Line.
Yes, good morning. I would just like to say this here. When Trump got voted into office, a lot of white people thought that they were not going to be affected by what Trump is doing now. White people are the most and the highest rating people that receive government-assisted food stamps. And now, all in red states, they are the ones who you see on the news out there on food lines and everything else. America needs to wake up. What Trump...
Oh, sorry, I thought you were done, Yvonne. Tucker is in Kansas, Republican line. Good morning, Tucker.
Good morning. How are you doing this morning?
Good.
Well, I'm currently a freshman here in South Bend, Indiana at the University of Notre Dame, and I'll tell you, I grew up in Yodeche where we raise show pigs and where I learned that hard work, it doesn't take sides. And while I call in as a Republican today, I really just want to talk about the state of America as a whole and how I believe we need to become more united. In my state, we talk a lot about politics, but we also talk about weather. We talk about feed costs. We talk about keeping our neighbors fed. And so, as we're discussing tariffs today, I understand that tariffs are extremely complicated. I understand that at times they can protect American industries, but at times they can also tighten margins for the farmers who rely on global markets, the people from my state who are most consequential to me. And so I just want to tell you, as I call in this morning and think about tariffs, I think about what it means as safety nets that work. Programs like SNAP are vital, but I also believe that they, and these issues that we're discussing during the government shutdown, but they must reach the families who truly need them most. And, one day I want to be governor of my home state, and I don't want to make Kansas more red or more blue, but I want to make it stronger, and I want to make it rooted in common sense and compassion and in a community. Because I believe that unity isn't about pretending we agree on everything, but it's about remembering that we rise or fall together as Americans. And so as we're discussing these issues this morning, in relation to the last caller who attacked one side of the aisle, I think that's inappropriate, because I think together as Americans, we need to come together and talk about these issues in unity, because we have the same patriotic spirit.
And Tucker, you said you're a freshman. What are you studying?
Yes, at the University of, thank you for the question, man. At the University of Notre Dame right now, I am studying political science, and I'm so honored to be here. For those listening at home who might be, seniors in high school looking for an opportunity where to go to college, I will say there is no greater place than the University of Notre Dame, because right here every single day we're fighting for the common good, and the common good is Americans and people all around the world who want an affordable way of living, and that's what we're hoping to provide through hard work, through perseverance. Anything is possible.
And Tucker, what are you doing as far as what are your plans on how you're going to become governor of Kansas?
Well, I want to thank you for that question as well, because to become governor, I think it starts with a solid background. I have a mother and father and a family who has taught me what it means to work hard. Coming from a rural agricultural background, it has taught me, what it means to wake up every single morning striving for something greater than myself. And that's the exact same message I want to bring to Kansans and I want to bring as governor, is that I'm not in office for political purposes. I'm not in there for personal gain. But I want to be governor because I want to help every single constituent in Kansas, and I want to bring a more affordable Kansas to every single family. And ultimately, I think Kansas is the greatest place to raise a family, and I want to make it better every single day to educate your children, to feed your family, and to support the community around you.
You sound like a politician, Tucker. You sound like you're ready.
Well, ma'am, I don't want to sound like a politician, but what I do want to sound like is a public servant who's willing to help the American people.
Well
and I
said.
will go to any cost to help them, and I hope I can do that, not just on your show today, but every single day moving forward.
Well
God
said,
bless you.
Tucker. Good luck to you. Kathy, Albuquerque, Democrat, good morning. You're on the air.
Hello. I guess I agree with you. That person sounded maybe not like a typical politician, but he sounded really great. That might be the future governor there. He was really great what he said.
Well, if he does become governor, Kathy, we'll have that in our archives, so we can always go back to it and say, you know, here's what the governor sounded like when he was a freshman in college.
Yes. He sounded great, everything he said. Actually, I just wanted to say I'm hoping that the Supreme Court will do the right thing. I kind of lost faith in them. They seem to be giving Trump a lot more power, and I'm just hoping they'll do the right thing. I know the lower courts have been holding, and so I have faith still a little bit in what's going on. But it just seems like Trump is using it to bully others. He's not consistent. And like I said, it's supposed to be Congress, but I hope Supreme Court does the right thing. I'll be watching and hoping. So thank you very much.
And here is Lawrence in Boca Raton, Florida, Republican. Good morning, Lawrence.
Good morning. To me, it's sad to see what the Supreme Court has done. And the problem for me started when they invented immunity for the executive, not only this executive, but every future executive. One point I wanted to respond to, Tucker has stars in his eyes, like every freshman in college, I suppose, including myself many years ago. But when he lands back on Earth, he's going to see how the sausage is really made. And it's not so easy in theory, in practicality as it is in theory. The last point, I grew up in the Pittsburgh area when the mills were busy. My friends' fathers worked for U.S. Steel, Westinghouse, Coppers. They all had good paying jobs, money in their pocket, and they bought things that they needed without concern and lived comfortably. That can't be duplicated. It cannot be brought back, no matter what some of your callers have insinuated. It's too much money, too late in time, and the cost of the goods. And it's unfortunate that we have to import our steel, but the cost of the goods would be a burden on industry in this country that we could not sustain. The last thing I wanted to make a note of is, I think it was Tucker or a prior caller who said that these tariffs are good for the farmers. Well, they weren't good for the farmers because the soybean crop in the upper Middle West couldn't be sold to China because of the tariffs until somebody shook the president awake and made him realize that he's losing the support of his base in the upper Middle West unless he finds some relief for those farmers. Thanks for your time.
And Lawrence, I think his point was that farmers rely on global markets. So I think he was against that. That was my understanding. But we'll go back out to the Supreme Court and talk to some people that are in line waiting to get in.
Hi, Mimi. It is almost 10 o'clock, so those Supreme Court oral arguments getting ready to start. Still a lot of people in line. You can see it goes all the way down to the front of the sidewalk. People hoping to get in. These are people who didn't win the lottery tickets, and so they're just waiting to see how many seats are available. One of those, fortunately, toward the back of the line is Johan. He's out here. He's been waiting. Johan, what time did you get here?
Well, I started getting ready this morning like at 7 a.m. But I got here a couple hours ago.
And why did you come out here today? Why do you want to see this case in particular?
Well, this case is really big for everyone, I guess. I mean, we're talking about the tariff with the President of the United States. So hopefully I was expecting to get something out of it, just trying to be in this at the Supreme Court and just trying to be here and trying to get good experience, and especially with the this tariff have impacted a lot with the tariff in South Korea continent as well for like semiconductors and automobiles as well. So I wanted to get some research done about it. So yeah.
And you said you haven't been to a Supreme Court case before, but you've been to other legal proceedings. What do you think you would take away from seeing a case in person versus listening to it?
I mean, well, sitting in person, I guess it makes a huge difference, right? I mean, you can you can chime in the online and get the transcript and then try to listen to it. But sitting in makes a big difference for everyone, just to get what the judges have to say, what what the opponents have to say. So, yeah, I mean, it makes a big difference. Yeah.
Have you been following this case?
Yeah, absolutely.
What would you expect to hear from the justices today?
I guess that's a tough question. I mean, I would say the case, I mean, I guess I can't say until after court convenes at 10, so I'll just put it up there. Yeah.
Johan, thank you so much for your time.
Yeah, thank you.
Back to your calls to Lee in Anaconda, Montana, independent line. Good morning, Lee.
Oh, yeah, I just wanted to say one thing. If you really want to open the government, all you really have to do is have all these people that are furloughed or not getting paid either go on strike or walk off the job or shut down all the transportation in America and a ripple effect across the world. That's all you got to say. Thanks. Have a good day.
And Michael in Wilmington, North Carolina, Democrat. You're next.
Hi, good morning. First of all, I want to congratulate everybody that won elections last night at the state, federal, county, city level, and hope they all understand there's a difference between winning an election and running a government, and I hope they all do the best for the people. But I have a question for you. When do you think C-SPAN is going to be on YouTube TV Live? I'm looking forward to watching as opposed to listening to you guys.
How do you watch us? How do you listen to us now? Are you?
I listen to you on my app.
Oh, you're on C-SPAN now on our app.
Right.
So YouTube TV and Hulu is coming soon. I don't have a date for you. If we find out, we will definitely be announcing it. So thank you for sticking with us on the app, and we're looking forward to it as well.
I'm looking forward to seeing you people.
Okay. Mel in Fort Smith, Arkansas, Republican. Good morning.
Good morning. Thanks for having me on the call. I'm a small business owner. I'm also a high school teacher. I teach construction, beginning construction to high school seniors because I believe we need more skilled labor. But I can tell you as a contractor and the cost of plywood, we've been paying an enormous amount for lumber and plywood that we ship our raw materials to China. They turn around and make plywood, and then they charge for the last 3 or 4 years triple what we used to pay years ago for our plywood. So I think we need to bring all of that back to the United States so that we're not getting ripped off by China. The other thing is that as far as Trump and tariffs, I do believe that Trump is a businessman. He's a negotiator. And that we need to, let him do what he does. It's not going to happen overnight, but what our country has experienced because of the lack of leadership is why we are where we are today, and the fact that once these things work, the Democrats won't be able to complain about where we are because they'll never be back in office with Trump doing what he does. And as far as the shutdown, our Democrats are the ones that are the leadership are not voting to open up our country. They need to do that. And, because the Republicans are voting to do it, but, our liberal media is not really showing that it's the Democrats' fault. So anyway, that's all I got to say about that.
And you've got on your screen the in front of the Supreme Court there is what you're looking at there. And we've got our C-SPAN cameras out there. We'll go to Mo while you're watching that. He's in Upper Marlboro, Maryland, independent line. Good morning.
Yeah, I was calling to comment about the Supreme Court today, but also Tucker inspired me to call. So the gentleman that called after Tucker that said that, he was young, has stars in his eyes, pretty much trying to rain on his parade. The gentleman is like maybe 19 years old if he's a freshman in college. And the way when I was 19, and even when the gentleman that called against Tucker that said he had stars in his eyes was 19, most of us, a large majority of us, did not have that type of mentality. You can just hear it in his voice. and I think he'll do well. And if there's anywhere where he can run and make a difference, is being a governor of Kansas, because you can do things better that you can't do as president as a governor. So I just wanted to say that I think he has a tremendous future ahead of him as in politics. He's going to be great. I ask for God's speed and blessings continued on him. But as far as the Supreme Court, there's precedence for this. I think this is going to be a slam dunk case. I know how Thomas, Roberts, Gorsuch, Kavanaugh, they're going to vote. I mean, because they're going to make arguments. I just don't see how you can argue against it. I would love, and even, what's her name, Ketanji has surprised me that she is following the law in the cases that she's represented. You know what I mean? And I think that's what all Supreme Court justices should do. But I think
Mo,
this is going to be
you're saying it's going to be a slam dunk for the president. Is that what you think?
For tariffs. For the
tariffs.
Yeah.
Yep.
I mean, I just don't see how you can. What would be the argument against it? But we'll see. And I think if it's unanimous, as there's been unanimous decisions, you'll see. I don't want it to be one-sided. I want them all to make the right decision, whatever that may be, based on the law that's presented.
And we are standing by for those oral arguments set to get started very shortly. But we'll continue our calls until then. Mark in Connecticut, Independent Line, you're on the air.
Hi, thanks for taking the call. This is a lot bigger than tariffs. This is, I believe the root of this is the separation of power. Whether the president has the right to do this, whether Congress has the right to stop them. Everybody is against Trump today, and since he walked down that elevator. And the picture you just showed on the screen of the women marching, I'm assuming they were handmaid tale or whatever that is. This is not about Trump. This is about the future of our country and whether a president and Congress has the authority to do what needs to be done. It's not tariff. I'm sorry, it's not. And everything is against Trump, He's not going to be in office in 3 years. But there's going to be another president after that, be it Republican or Democrat. Okay, you cannot hold, and I kind of agree with John Thune as far as not ending the filibuster. Because this is not about today. This is about the future of this country. And until people get off of the Trump bandwagon and realize that it's not, that all he's trying to do is make this country better. And I heard Hakeem Jeffries this morning with a new, I believe, Democrat phrase, something about America best. I forgot what he said now. I just lost my train of thought.
That's okay, Mark. We'll go to Jim, Tucson, Arizona, Democrat. Good morning, Jim.
Good morning, and thank you for having me. I love watching C-SPAN, and I just have to say I love listening to the Republicans because each and every one of them is a parrot for what Donald.
And sorry, Jim, we're going to have to end it right here on today's Washington Journal because the Supreme Court is getting underway, and we'll take you there right now. Thanks for watching.
Has created a public health crisis, taking hundreds of thousands of American lives. President Trump has declared that these emergencies are country-killing and not sustainable, that they threaten the bedrock of our national and economic security, and that fixing them will make America a strong, financially viable, and respected country again. Due to IEEPA tariffs, President Trump has negotiated agreements worth trillions of dollars with major trading partners, including most recently China. Unwinding those agreements, he warns, would expose us to ruthless trade retaliation by far more aggressive countries and drive America from strength to failure with ruinous economic and national security consequences. In Dames and Moore against Regan, this court held that IEEPA's sweeping and unqualified language grants the president's actions the strongest presumption of validity and the widest latitude of judicial interpretation. Yet plaintiffs argue that tariffs, IEEPA's least blunt and most nimble tool, are virtually the only tool that Congress did not grant the president to deal with foreign emergencies. That is wrong. The phrase regulated importation plainly embraces tariffs, which are among the most traditional and direct methods of regulating importation. And plaintiffs concede that IEEPA authorizes quotas and other tariff equivalents. The major questions doctrine does not apply here. IEEPA confers major powers to address major problems on the president, who is perhaps the most major actor in the realm of foreign affairs. And the non-delegation doctrine casts no doubt on IEEPA because Congress may assign the president broad authority regarding the conduct of foreign affairs where he enjoys his own inherent Article II powers. I welcome the court's questions.
Would you spend a few minutes on why exactly the major question doctrine doesn't apply to the president in this case?
Yes, Justice Thomas, and I maybe make 2 or 3 points on that front. First of all, though the major questions doctrine may apply to the president in other contexts, specifically in the foreign affairs context where he has his own inherent Article II authority, it's a particularly poor fit to apply the major questions doctrine, and that's for at least 2 reasons. First of all, just as a matter of kind of common sense interpretation, one would expect Congress to confer major powers on the president to address major, sort of foreign, international crises, so to speak, in foreign arising emergencies, that's just sort of a natural common sense thing you expect Congress to do. And in fact, Justice Jackson in his Youngstown opinion addressed this very situation in pages 652 and 653 when he says, this is the system within this is the procedure within our constitutional system that we have developed to strike the balance. What Dames and Moore described as the never-ending tension between the need for the executive to have robust powers to address emergencies and to subject it to checks and balances. What our constitutional system has devised to address that particular problem, that never-ending tension, is the system where Congress confers broad administrative powers in advance and subjects them to ongoing political oversight, which is exactly what you see in IEEPA. So that's one reason. One reason, just as a matter of common sense interpretation, you would expect Congress to grant major powers to the president, who has his own broad range of major authority, inherent Article II authority in this context. And that is buttressed by the second point,
which is— Can I interrupt you, General, there? And I know that you have a second question, and I want to let you get to that. But just on that first reason, it seemed to depend a lot on the president's inherent Article II powers. And I'm wondering what exactly, which powers you're speaking of there. Because tariffs, one would naturally think, are the power to impose taxes, the power to regulate foreign commerce. These are not things that are thought of as Article II powers. They are quintessential Article I powers. So what kind of Article II powers are you relying on when you gave the answer about major questions to Justice Thomas?
I would refer to what the court said, for example, in Egan, Department of Navy against Egan. That's a generally accepted view that the president has broad authority in the foreign affairs realm. Now, there's been debates about exactly how far it goes and how to draw the boundary between the president and Congress, but Egan, Garamendi, other cases, Curtis Wright, the court has recognized the president has broad inherent authority to address foreign situations, foreign affairs, foreign policy, including foreign arising emergencies. Now, we don't contend that he has, at least in peacetime, inherent tariffing authority. What we have here is 2 layers. There's the layer, the bedrock of the president's inherent Article II powers, and layered on top of that is a sweeping delegation of authority from Congress. When you put those 2 things together, Congress is saying you have inherent powers to address international emergencies, and we're conferring on you the tools, including Article I tools, like, for example, the power to regulate foreign commerce. And I want to make a very important distinction here. We don't contend that what's being exercised here is the power to tax. It's the power to regulate foreign commerce. These are regulatory tariffs. They are not revenue-raising tariffs. The fact that they raise revenue is only incidental. The tariffs would be most effective, so to speak, if no person ever paid them, if they achieve their goals.
Counsel, you've already mentioned Dames and Moore three times, which surprises me a little because the court in Dames and Moore went out of its way to say that it was issuing a very narrow decision that pretty much expected to apply only in this case. Just a few quotes. It said, decisions in this area have been rare, episodic, and afford little precedential value for subsequent cases. Again, we lay down no general guidelines covering other situations not involved here and confine the opinion only to the very questions necessary to decision of this case. And it ended the opinion. It said, finally, we re-emphasize the narrowness of our decision. Now, this at issue in Dames and Moore was a different provision of IEEPA, not at issue here, and certainly did not concern tariffs. So I don't quite understand how you can get as much out of Dames and Moore as you're trying to get.
Maybe I could put it this way. We don't dispute that Dames and Moore is, as you state, a narrow opinion. However, it address certain principles that we think are equally applicable here. For example, the interpretive principle. Dames and Moore held, and again, it was the power to nullify and void, not the power to regulate, but it's in the very same sentence, in the very same statute, and the court quoted the First Circuit opinion and said, look, this is sweeping and unqualified language, which it didn't disagree with. And then it said, this particular provision where Congress has given these broad verbs, I mean, regulate is a capacious verb, admittedly, so are nullify, so are void, so are frankly all the other verbs there in the language in IEEPA. The way the court thought about it is we are looking at this through the lens of Justice Jackson's opinion in Youngstown, and the court held specifically that these verbs place the president in Youngstown's own one. The court held that he is subject to the widest latitude of judicial interpretation, that he receives the strongest presumption of validity.
I just don't understand this argument. It's not an article. It's a congressional power, not a presidential power to tax. And you want to say tariffs are not taxes, but that's exactly what they are. They're generating money from American citizens, revenue. And you say it's incidental to the regulatory purpose. But I don't see how a quota is equivalent to revenue raising. A quota sets a limit to what you can import in, but it doesn't generate revenue. I don't understand this argument, that it's equivalent, or that foreign powers or even an emergency can do away with the major questions doctrine. Didn't we in the Biden case recently say an emergency can't make clear what's ambiguous?
As to that point, I believe the court has never applied the major questions doctrine in the foreign policy context.
But we have,
emergency context, not foreign policy
counsel,
context.
We have never applied it to foreign affairs, but this is a tariff. This is a tax.
It is a, if I may, it's a foreign-facing regulation of foreign commerce. That's a regulatory tariff distinct from a tax.
So Biden could have declared a national emergency in global warming and then gotten his student forgiveness to not be a major questions doctrine?
I don't think he could have gotten student loan forgiveness.
Why?
But
It's global. It's foreign-facing. We need all of these things to face to tax fossil fuel or to do something else. That's all Biden would have had to do with any of his programs.
Let me put it this way, if I may.
Is just declare some foreign-facing purpose?
If I may, maybe I can articulate it this way. The power to impose tariffs is a core application of the power to regulate foreign commerce, which is what the phrase regulate importation in IEEPA naturally evokes.
Why
not the power to tax.
Could you tell me why it is that when Congress intended to permit a president to regulate by imposing tariffs, it's always used tariff and regulate? I have about 16 laws in the past that when Congress intended regulate to mean taxing, that it used taxes simultaneously. But it didn't here.
Respectfully, this court came to the opposite conclusion, if I may, in Algonquin, where the phrase was not impose duties.
Well, but that was, we did something in Algonquin. It was in the duties section, unlike here. It was paired with questions about decreasing tariffs and increasing tariffs. So it's a very different statute than the one at issue here.
But the governing language, admittedly, the references to duties in Section 232A, 232C does not refer to them, and the court didn't refer to 232A at all, or the phrases duties or tariffs as analysis. What it held was the phrase adjust imports, which includes a verb that's narrower.
But it was in the
context.
It was in context of activities that had to do with raising and lowering duties. Here, the verbs that accompany regulate have nothing to do with raising revenues in the form of taxes.
And counsel, Algonquin wasn't a textualist opinion. Do you agree with that? In other words, the analysis that the court was using there was really keyed to the legislative history of that statute, and it wasn't as though we were doing an interpretation of the word adjust.
I disagree with that. I think you read the opinion, first it talks about plain meaning, then it talks about statutory context, and then it goes on to legislative history, so it was all three of those. And the conclusion it came to, it directly addressed and rejected the argument that the D.C. Circuit had accepted in that case, which is that when Congress wants to delegate the authority to tariff, it uses a consistently explicit and well-defined approach, which is to use these magic words, tariff, tax, impost, and so forth.
All right,
the court said, no, Congress is not bound to use that particular formulation when it wants to confer this power.
Let me ask you about the premise of your argument, which you sort of started at the beginning saying that one would expect for Congress to give the president a broad leeway in this kind of foreign affairs context. And I guess I'm wondering whether you also don't have to contend with the actual purpose of IEEPA in making this argument, because as I understand it, that the IEEPA was designed and intended to limit presidential authority, that Congress was concerned about how presidents had been using the authority under the predecessor statute, TWIA, and it's pretty clear that Congress was trying to constrain the emergency powers of the president in IEEPA. So it seems a little inconsistent to say that we have to interpret a statute that was designed to constrain presidential authority, consistent with an understanding that Congress wanted the president to have essentially unlimited authority.
I disagree with that, because what Congress actually did as—
What part do you disagree with? I'm sorry.
Well, I disagree with the notion that they were trying to constrain the breadth of the actions the president may take when it comes to this particularly narrow domain, which is, various regulations of transactions.
But how can you disagree with that? I mean, the history is what it is.
Because they made a series of changes to IEEPA that relate to the triggering conditions, so to speak, and the procedures that apply, but they did not change the language.
Right, but what was the intent of Congress in changing the language? Wasn't it to constrain presidential authority in this area?
To constrain it in the triggering conditions and the procedures that apply in this—
No, those are the triggering context. The triggering conditions and procedures that apply are a means to constrain. That is how they went around about constraining. But my point is that Congress enacted this legislation with the intent of preventing the president from having unlimited powers in this area, and you're asking us to now interpret that statute consistent with an understanding that Congress wanted to allow the president to do pretty much whatever he wanted in this area.
Congress took the language from TWIA and enacted the very same language, and most importantly here, the very same phrase, regulate importation, in IEEPA. And therefore, the natural inference is Congress did not intend to change the scope of authority, the powers, the tools the president can exercise.
Did any president under TWIA use that language to impose tariffs?
Well, yes, President Nixon's 1971 tariff.
Not a tariff. That wasn't a tariff. It was a licensing agreement during wartime. It was a specific thing. A tariff I'm talking about.
I'm referring to President Nixon's 1971 tariff.
I'm sorry, excuse me. Yes, I thought you meant Lincoln.
Not only that, but then it was upheld by the Court of Appeals with exclusive jurisdiction under this very phrase.
Can I back you up just a second? I'm sorry. You're talking so quickly.
Sorry.
President Nixon did not rely on TWIA initially to impose the tariffs. Is that correct? I understood that was just a litigating position that he took once it was challenged. That was not his initial.
I wouldn't put it that way, because he has a broad invocation. I'm invoking all range of statutes, something like that, in Proclamation 4074. And I think the understanding is he didn't want to kind of spook our allies by invoking the Trading with the Enemies Act, by specifically invoking it, but in litigation it was defended on that ground. So the Department of Justice defended it as an exercise of TWIA and did so successfully.
What's the significance of the Nixon example and precedent here? Because I think figuring that out is real important to deciding this case correctly. So,
well, there's one obvious, very powerful takeaway from it, which is that this very two-word phrase, regulate importation, that we say it carries with it the authority to tariff, impose regulatory tariffs at the border, forward-facing tariffs at the border, and we say that's a core application of the phrase regulate importation, had been interpreted 2 years before Congress reenacted that language in IEEPA, had been interpreted to carry with it the authority to impose tariffs. So this court said in Algonquin, for example, with respect to President Nixon's—
just back on the Nixon, what was the scope of the Nixon tariffs?
10%, he imposed a 10% tariff kind of across the board to all our major trading partners to address a balance of payments deficit, where he was trying to bring all the major industrial nations to the negotiating table, which he successfully did, for the imposition of the tariffs, and they negotiated the Smithsonian Agreement in about 5 months, after which he lifted the tariff. So the tariff there was used as here, in part as leverage to get our trading partners to the negotiating table, and it was subsequently upheld by the Federal Circuit, the CCPA, its Federal Circuit's predecessor, that had exclusive jurisdiction over that question, to include the power to tariff. And then 2 years later, Congress took that same phrase and reenacted it in IEEPA after carefully studying the problem of presidential emergency powers and being deeply concerned about, excessive or abusive exercise of that power. So that whole sort of process gives sort of strong sort of confirmation that this phrase, regulated importation, carries with it the power to tariff. Now, of course, that's not our leading argument. Our lead argument on interpretation is there's a pedigree, historical pedigree of regulating imports specifically, where the power to tariff is just the sort of a core application of that, a quintessential exercise of that power. That goes back to Gibbons against Ogden and Justice Story's treatise, and runs all the way through cases like McGoldrick and Board of Trustees of Illinois.
Sauer, can I just ask you a question? Can you point to any other place in the code or any other time in history where that phrase, together, regulate importation, has been used to confer tariff-imposing authority?
Well, as to regulate importation, that was held in TWIA. So obviously, and that's...
Okay, so an intermediate appellate court held it in TWIA, but you just told Justice Kavanaugh that wasn't your lead argument, that your lead argument was this long history of the phrase regulate importation being understood to include tariff authority. So my question is, has there ever been another instance in which a statute has used that language to confer the power? Well, putting aside Yoshida.
I mean, obviously, other statutory example is just imports. The cases we rely on are cases where, for example, in Gibbons it's Ogden and Justice Story's treatise.
But that just shows the word can be used that way. None of those cases talked about it as conferring tariff authority. I understood you to be citing McGoldrick and Gibbons in those cases just to show that it's possible to say that regulating commerce includes the power to tariff.
I think our argument goes a bit further than that as an interpretive matter, because if you look at that history, the history of delegation...
Could you just answer the Justice's question?
Can you identify any statute that used that phrase to confer tariff?
Yeah, the only 2 statutes I can identify now are TWIA, as interpreted in Yoshida, and then closely related, not regulate importation, but adjust imports in section 232.
Well, I think adjust imports is differently. So the answer is the contested application in TWIA, and then now in IEEPA.
And then, of course, I mean, there's a sort of direct line there.
Yeah, I understand that, but
yes.
Okay.
But then more fundamentally, we rely on the historical sources to show there's this long historical pedigree of broad delegations of the foreign commerce power, not the power to tax that we're not asserting here, delegations of the foreign commerce power to the president, going back to Gibbons against Ogden, all the way through McGoldrick and Board of Trustees, where this court and founding era sources say the power to, in other words, the power to tariff is kind of this natural, as everyone knows, that includes...
Just ask you one other question about the plain text, General Sauer. So you've referred to the other verbs in IEEPA as capacious. Would you really describe them as capacious? Because to me, things like nullify and void have definite meanings. I agree with you that regulate is a broader term, but those words I think are powerful. They pack a punch, but I wouldn't describe them as capacious in the sense that they have a wide range of meaning. So can you describe what you mean by capacious?
Let me put it this way. You look at all 9 verbs together, and you're looking at a spectrum of powers from the most sort of negative, nullify, block, prohibit, void, to the most affirmative, direct, compel, and then also powers in between that are more intermediate, regulate, investigate, and so forth. So the natural common sense inference from that grammatical structure is the intention of Congress to sort of cover the waterfront.
Well, possible, except Congress did take out a whole bunch of verbs. It took out confiscate, vest, hold, use, administer, liquidate, sell, which were in the prior statute. And crucially, what it doesn't have here is anything that refers to raising revenue. So it has a lot of verbs, it has a lot of actions that can be taken under this statute. It just doesn't have the one you want.
Well, I would say the notion that all these other verbs are sort of not revenue-raising, like block and prohibit, I think that argument is unconvincing for two reasons. One, of course, is that we're not saying it confers a revenue-raising power. We're saying it confers a regulatory power, and that's a crucial distinction. But also—
Yes, but if I can just stop you there, regulatory power, I mean, yes, it says regulate, but I'll broaden out Justice Barrett's question. Is there any place that you can find in the entire code where regulate, used just as regulate, includes taxing power?
We don't assert that. We say it includes tariffing power when it's combined with importation, and that's just the most natural—
Right, because the natural understanding of regulate, even though, in fact, we can regulate through taxes, but when the code uses regulate, we don't typically understand it to refer to duties or taxes or tariffs or anything of the kind. And then if you look at the flip side of this, and you look at all the tariff statutes that Congress has passed, I mean, they use language about revenue raising, tariffs and duties and taxes, all the language that does not appear in the statute you rely on.
Start with sort of grammatical structure of the statute, then refer to the other statutes. Regulate importation. You put those two words in combination. That's the inference from that is, the founders discussed with this sort of like, as everyone knows attitude. Regulate importation, one of the most natural applications of that is the power to tariff. So when Congress confers the power to regulate imports, it is naturally conferring the power to tariff, which it has delegated to the executive branch, again and again and again.
I'm sorry, counsel. It doesn't say regulate tariffs. It says regulate importations and exportations. You agree that they can't put taxes on exportations?
From the states, yeah, we agree with that, yes.
All right. So why should we think that it's natural then to think that regulate importation includes taxing importations?
Because that is how—
It's in the conjunctive, importations and exportations. If they can't do it with respect to exportations, why are we permitting them to do it with respect to importations?
Because as this court has recognized, going back to Gibbons against Ogden and going through McGoldrick and Board of Trustees, the phrase, when you're regulating imports, tariffing is a core application of that. So in other words, if you're saying go regulate trading in securities,
so
that doesn't come with a tariffing connotation.
Why is it that Congress has always used regulate and tax together in the code? Are you telling us that with respect to its use of regulate in other statutes, the taxing reference is superfluous? They didn't need to do that?
I'm not sure what other statutes use regulate and tax together, but this statute has a specific historical pedigree going back to its enactment during World War I in 1917, where the phrase regulate importation is evoking an inherent power to tariff that became established in the 19th century in cases like Hamilton against Dillon and so forth, and that history is, I think, set forth in Professor Baumsei's amicus brief.
Counsel, some time ago you dismissed the applicability of the major questions doctrine, and I want you to explain that a little bit more. I mean, it seems that it might be directly applicable. You have a claim source, an IEEPA, that had never before been used to justify tariffs. No one has argued that it does until this particular case. Congress uses tariffs in other provisions, but not here, and yet, and correct me on this if I'm not right about it, the justification is being used for a power to impose tariffs on any product from any country in any amount for any length of time. That seems like, I'm not suggesting it's not there, but it does seem like that's major authority, and the basis for the claim seems to be a misfit. So why doesn't it apply again?
Well, we agree that it's a major power, but it's in the context of a statute that is explicitly conferring major powers, that the point of the statute is to confer major powers to address major questions, which are emergencies. So it'd be unusual to say, look at the statute and say, we're not going to find a major power here.
Well, but the exercise of the power is to impose tariffs, right? And the statute doesn't use the word tariffs.
But it uses the word regulate importation. And historically, a core central application of that, a big piece of that, has always been to tariff. If you had asked the founders, how do you regulate imports? They would say, of course, we tariff. That's what we do. So it'd be very unusual to say, we're giving you power to regulate importation, and say, but you cannot impose regulatory tariffs. That'd be almost a contradiction. And all the historical sources we cite in our brief, relate to that particular historical pedigree. And as I was referring to earlier, there's a specific pedigree of regulated importation here in the specific context of the Presidents Polk and Lincoln and President McKinley asserting the authority to impose tariffs in wartime that was then codified in TWIA and then recodified for peacetime in TWIA in 1933 and then carried over into IEEPA. So there's that as well. But more importantly, if you look at the sort of triggering conditions that members of this court have identified for the major questions doctrine, there's a series of them, and we think they really do, all of them don't apply here. For example, the notion that the power is unheralded. You referred to the fact that IEEPA has never been asserted to invoke tariffs, but of course, the immediately predecessor statute, the tariffs that President Nixon imposed on that were upheld under this very language. So this, I would say this is, and it was recodified in IEEPA 2 years later. So this is kind of the opposite of unheralded power. It's also heralded because there's this long-standing delegation, a tradition of very broad delegations of the foreign commerce power going back to the founding, going back to
the foreign commerce part. But I mean, and I think this is a question for the other side as well. It's two-facing. Yes, of course, tariffs in dealings with foreign powers, but the vehicle is imposition of taxes on Americans, and that has always been the core power of Congress. So to have the president's foreign affairs power trump that basic power for Congress seems to me to kind of at least neutralize between the two powers, the executive power and the legislative power.
Let me say two things in response to that. First, the notion that the taxes are all borne by Americans and are not borne by foreign producers whose goods are imported is empirically, there's no basis for that in the record. It's actually a mixed.
Well, who pays the tariffs? If a tariff is imposed on automobiles, who pays them?
Typically there'd be regardless of who the importer of record is, there'd be a contract that would go along the sort of line of transfer that would allocate the tariff, and there'd be different. Sometimes the foreign producer would pay them. Sometimes the importer would bear the cost. The importer could be an American, could be a foreign company. A lot of times it's a wholly owned American subsidiary of a foreign corporation. So it gets allocated. The empirical estimates range from like 30% to 80% of like how much is borne by American
I mean, it's
citizens.
been suggested that the tariffs are responsible for significant reduction in our deficit. I would say that's raising revenue domestically.
There certainly is an incidental and collateral effect of the tariffs that they do raise revenue, but it's very important that they are regulatory tariffs, not revenue-raising tariffs. And the way you can see this, I think, if you look at this policy is by far the most effective if nobody ever pays the tariffs. And I say two policies, right? So if you look at the trade deficit emergency, if nobody ever pays the tariffs and instead Americans direct their consumption towards American producers and stimulate the rebuilding of our hollowed out manufacturing base, then the policy is by far the most effective. So a tariff, a regulatory tariff that...
Why not do what the statute permits? Bar importation of products altogether. That would be the most effective way to do it.
The question
you follow the statute. The statute says the president can do that. What it doesn't say is the president can raise revenue.
What it says is he can regulate importation and go back for hundreds of years the way you regulate imports.
Pausing it, subjecting some countries and not others to importation bans. There's a lot of verbs, but none of them include generating revenue as a side effect or directly.
Let me address that verb point, if I may, because think about the canonical example, a statute that refers to a list of swords, knives, daggers, dirks, and pikes. There you look at that list of things and you say, aha, those are all weapons, therefore a pike is a spear, not a fish in that particular context. Now look at this list of verbs, block, prohibit, compel, direct, and so forth. You don't look at that naturally as an ordinary reader and say, oh, look, they're all not revenue raising. What you say is they're all very broad, powerful, actions that you can take.
The verbs that are in the statute are actually doing something. I mean, they're in the statute for a reason, and as I understand it, Congress actually explained to us in its Senate report and House report when it enacted the 1941 amendments to TWIA, what it was doing. It said that what we are doing is authorizing the president, in the Senate report, quote, to control or freeze property transactions where a foreign interest is involved. There's similar language about controlling, freezing control in the House report. So I appreciate that generally you can look at these words and you can imagine that they mean certain things, but here we have evidence that Congress was actually trying to do a particular thing with respect to the authority that it was presenting to the president, and that thing was not raising revenue.
I think that the powers that Congress was conferring on the president are best understood through the plain text of the statutes, which includes regulating importation.
No, I know, but some of us care about the legislative history. And so the plain text of the statute has certain verbs in it. It also has regulate commerce, as you say. And when I look at the legislative history, it appears as though Congress was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And in the TWIA context, that makes perfect sense because we're talking about a wartime dynamic. And what is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of this statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when, in fact, it looks as though the aim of this was really to give the president a certain kind of authority to freeze the assets of the enemy.
And let me say two things in response to that. First, as the notion that this is a revenue-raising tactic or power, it is not. We are asserting a regulatory power. It's a delegation of the power to regulate foreign commerce. The way to control imports traditionally has been to tariff them. They say, well, you can impose quotas. Well, quotas are essentially economically equivalent to tariffs. So the question is, why would you be able to quota under-regulate but not tariff under-regulate when the tariffs are themselves regulatory? And let me turn back to the question the response I was giving to the Chief Justice to illustrate that.
Could the answer be that in other places where Congress wants that particular form of regulation to be used, they say impose duties. They say you can tax, Mr. President. Here they don't say that.
I'd say two things in response to that. That's the very argument that this court rejected in Algonquin. That the fact that these other specific statutes,
if we disagree
with you about way you have to.
If we disagree with you that Algonquin is a similar context, do you have another statute or another circumstance?
And again, not to cite Algonquin again, but obviously yes. we discussed the phrase adjust imports, and they said the natural way to do that is to tariff them, and they specifically said it makes no sense at all to authorize quotas, which was conceded that statute did authorize, but not tariffs because those are equivalent.
But it said adjust by any means necessary, which kind of beefs up the adjust. And also, and this is actually, I just don't know the answer to this question, so maybe you can help and maybe the other side can help as well. Algonquin was very careful to always call it a license and a licensing fee, and in the oral argument that came up too, the distinction between a tariff and a licensing fee. And I can understand how in some contexts it would be very difficult. You would press on it and you would say, well, if this license fee is raising revenue, then it actually functions as a tariff. But what is the significance of that? Because in IEEPA, it also says, it refers particularly to licenses. It says you can license. And license would be a way of giving permission. That's actually the language also used in the Civil War one. And what is it?
Hamilton against Dillon. Yeah. Exactly. Yes, it does.
It was a license. It was a license fee. And that's a way to grant permission that you wouldn't otherwise have to trade and import and let it through. So tell me what the distinction is between licenses and fees and if it matters.
It's hard for me to see one because what President Lincoln said is, okay, we're going to allow imports from hostile foreign powers, basically rebellious Confederate states, of cotton subject to a license, but you got to pay 4 cents a pound on cotton. When you do it, that's the condition. That is so nearly equivalent to a tariff that says you can bring these goods into our country, but you got to pay a ad valorem assessment on it. And of course, they have in their briefs conceded that quotas apply, that licensing may apply. There is the language in the beginning of 1701 that talks about instruments, or other methods, instruments, licenses.
But if that were true, why couldn't you just call this a license? And it's also true that in the cotton example, the court said the exaction itself was not properly a tax, but a bonus required as a condition precedent for engaging in the trade. So it seems like it was a little squirrely about how it was proceeding. And if there really is no distinction, why couldn't you just call it a license here?
Very briefly, the other two cases, the Polk case and then the President McKinley case, talk about duties. So I see an equivalence there, Mr. Chief Justice.
Thank you, counsel. Justice Thomas, anything further?
The other side is going to argue, make an argue on delegation, I believe. Would you anticipate that and give us your understanding of the delegation argument?
Yes, Justice Thomas. I'd say a couple things in response to that. First of all, this court has stated that the non-delegation doctrine does not apply with anything like the same force as it does in the domestic context in the foreign context. And that, again, to cite Dames and Moore again, Dames and Moore cites Youngstown, and Youngstown in footnote 2 of Justice Jackson's opinion, he goes into